Good morning, everyone. Welcome to the Joint Standing Committee on the Judiciary. We are here this morning to begin our work with the confirmation hearing for the Honorable Valerie Stanfill for the position of Chief Justice of the Maine Supreme Court. And then we'll conclude our work today with a number of language reviews on amendments to legislation that we've worked on throughout the session. We will begin with committee introductions, as is our usual process. And I am going to call on committee members, starting with Senator Heather Sanborn.
Good morning, everyone. Thank you, Senator Carney. My name is Heather Sanborn. I represent Senate District 28, which is half of Portland and half of Westbrook.
Thank you. And next, Representative Babbage.
Yes, good morning, everyone. My name is Christopher Babbage. I'm privileged to represent House District 8, which is most of the town of Kennebunk.
Thank you. And Representative McCreight.
Good morning, everyone. I'm Jay McCreight, representing Harpswell, West Bath, and Northeast Brunswick in the House.
Thank you. Representative Cardone.
Hello, I'm Barbara Cardone. I represent House District 127, part of Bangor.
Thank you. Representative Moriarty.
Good morning, all. I'm Steve Moriarty. The sun is shining in my hometown of Cumberland, which is the majority of my district, but I also represent part of Gray.
Thank you. And Representative Poirier.
Thank you, Madam Chair. I am Jennifer Poirier. I represent House District 107, which is all of Skowhegan and part of Madison.
Thank you. And Senator Keim, would you like to introduce yourself?
Good morning, everyone. My name is Lisa Keim, and I'm honored to represent Senate District 18, which is northern Oxford County, in two communities in Androscoggin.
Thank you. And Co-Chair Harnett.
Thank you, Madam Chair, and welcome all. My name is Tom Harnett. I represent House District 83, which is the town of Farmingdale and the city of Gardner, where I reside.
Thank you. And we are joined today by our committee clerk, Susan Panett, and also our analyst, Peggy Reinsch. And I am Ann Carney. I represent Senate District 29, which includes South Portland, Cape Elizabeth, and a little bit of Scarborough. And we've just been joined by a few additional members of our committee. Representative Evangelos, would you like to introduce yourself?
Thank you, Senator Carney. Jeffrey Evangelos, House District 91. I reside in Friendship.
Thank you. And Representative Sheehan?
Thanks, Madam Chair, and good morning, everyone. My name is Erin Sheehan, and I represent Biddeford's House District 12.
Thank you. And so we will begin. We have some other, and we've just been joined by Representative Reckitt as well. Representative, would you like to introduce yourself?
Thank you. My name is Lois Reckitt, and I represent the ocean end of South Portland.
Thank you very much. And we have some other people on the screen. They will be introduced as we proceed through the confirmation hearing. And so I will begin the confirmation hearing with following the script that we are required to follow. So bear with me, please, while I do some reading. This is a public hearing of the Joint Standing Committee on the Judiciary for the purpose of considering the nomination by the Governor of the Honorable Valerie Stanfill of Wayne for appointment to the Chief Justice, Supreme Judicial Court, and Justice of the Law Court. Under the law and joint rules of the legislature, this committee is required to hold this public hearing and to recommend confirmation or denial of the nominee by a majority vote of the committee members present and voting. As chairs of the committee, Representative Harnett and I will then send written notice of the committee's recommendations to the President of the Senate. The committee will hear testimony from and have an opportunity to question the governor or her representative, the nominee, and any other persons present who wish to speak for or against the nomination. This meeting is currently being live streamed on the committee's YouTube channel. This means that anyone who is a participant in the electronic meeting via Zoom can be seen and also heard if their microphone is unmuted. People testifying cannot be seen or heard until they are called upon to speak. This meeting will be recorded and available to view on the committee's YouTube channel soon after our meeting today has concluded. We will begin with a motion to confirm. Pursuant to Title III, Section 157 of the Maine statutes, which requires that there be an affirmative motion to recommend confirmation of the nominee, the chair recognizes co-chair Tom Harnett for the purpose of making such a motion. Representative, we're not able to hear you.
Sorry about that, Madam Chair. I move the Joint Standing Committee on Judiciary recommend confirmation of the Honorable Valerie Stanfill of Wayne for appointment as the Chief Justice of the Maine Supreme Judicial Court.
And Justice of the Law Court.
And Justice of the Law Court.
Thank you. Is there a second to the nomination?
Second.
Seconded by Representative Moriarty. A copy of the statutory requirements for this position is available online at the request of anyone who would like to see it. The chair now recognizes Jerry Reed, Chief Legal Counsel for Governor Mills, for the purpose of making a statement concerning this nomination.
Good morning, Senator Carney and Representative Harnett, members of the Judiciary Committee. I'm Jerry Reed, Chief Legal Counsel to Governor Mills, and it's an honor for me to be here this morning to present Justice Valerie Stanfill as the governor's nominee for appointment as Chief Justice of the Maine Supreme Judicial Court. Justice Stanfill has had a remarkable career that has included public service, private practice in both law firms and as a sole practitioner, academic instruction, and service on both the district and superior courts. In each of these settings, she has excelled, distinguishing herself with her intelligence and work ethic. After graduating from Bryn Mawr College with a degree in history, she enrolled at the University of Maine School of Law. Not surprisingly, she was an outstanding student at Maine Law, where she was on the board of editors of the Law Review, and also worked as a summer associate at one of Portland's leading firms. During her time there, she was the only woman who worked at that firm other than support staff. She went on to earn her law degree, magna cum laude. Upon graduation, she served in a clerkship to the Chief Justice of the Superior Court based in Androscoggin County. She then joined a prestigious trial firm in Lewiston, where she became only the second woman partner at that firm and was the only female partner during her 11 years there. She left to found her own practice in Auburn, specializing in litigation services, which she ran for 4 years. In 1999, she joined the faculty of the University of Maine School of Law as visiting clinical professor of law, where she taught classes in trial practice. She also served as the acting director of the law school's Cumberland Legal Aid Clinic, which provides legal services to indigent clients. There, she developed new programs to support both victims of domestic violence and prisoners. At the same time, she was instrumental in the development of the Campaign for Justice, the fundraising initiative that supports Maine's legal services providers. After another year of law firm practice, she was nominated and confirmed as a judge of the Maine District Court in 2007. Governor Mills nominated Judge Stanfill to the Superior Court in 2019, and she was confirmed as a justice in January of 2020. Justice Stanfill has earned a reputation as an exceptionally smart and capable jurist with particular skill in trial management. She's an expert in issues of domestic violence, criminal law generally, and family law. She is highly respected by her colleagues and regularly serves as a mentor to less experienced judges. She has been tested during her time on the bench by difficult, controversial, and precedent-setting cases, and when tested, has risen to the occasion. By way of example, in 2007, the case of State v. Italian, she dismissed the state's complaint against the defendant for failure to register with the sex offender registry. Judge Stanfield ruled that the retroactive application of the statute violated the ex post facto clauses of both the Maine and US constitutions. And the law court upheld her decision in an opinion that closely tracked her reasoning. I was in the Attorney General's office at the time of her decision. I remember it well, and it was a big deal. That decision demonstrated her willingness to make decisions as a district court judge that might be unpopular as a matter of public opinion, but that were required to protect the constitutional rights of the defendant. Justice Stanfield's career has been characterized by accomplishment and courage. She has proven herself worthy of leading our judicial branch. It's a great pleasure for me to recommend her on behalf of Governor Mills for appointment to be Chief Justice of the Maine Supreme Judicial Court. Thank you very much, and I'd be happy to answer any questions the committee may have.
Thank you very much, Jerry. Committee members, are there any questions? Representative Babbage, did you have a question?
Yes, thank you, Madam Chair. Mr. Reed, good to see you again, and thank you for coming forward with this nomination. If asked, could you, well, I'm asking you, could you help explain, just for public recognition of why we've actually had a 13-month period prior to this nomination?
Yeah, thank you for that question, Representative Babbage. I think it's an important question. And really what it comes down to is that that period is a reflection of how seriously the governor took the process of identifying the right candidate for this important position. And the search began long before I started in this position in September of last year. And it has continued with great effort since I've been here. And we have conducted the sort of exhaustive review and search that I think this committee would expect of us. And even positions for seemingly inconsequential boards and commissions where the governor appoints members of the public to assume a role. Those decisions get an incredible amount of scrutiny in this office. And a judge of the district court gets much more, and of the Superior Court more than that. And for a Chief Justice of the Supreme Judicial Court, the level of scrutiny that was applied in reviewing suitable candidates for this position was really exceptional. So that's what accounts for the 13-month delay since the time this position became vacant.
Thank you.
Committee members, any additional questions for Jerry Reed? I'm not seeing any. Thank you so much for your statement.
Thank you.
The chair now recognizes John Hobson, Chair of Governor Mills Judicial Nomination Advisory Committee, for a statement on behalf of the nominee.
Thank you very much, Senator Carney, Representative Harnett, members of the Joint Standing Committee on the Judiciary. My name is John Hobson, and I am Chair of Governor Mills' Judicial Selection Committee. On behalf of the Selection Committee, I request that this committee act favorably on the nomination of Justice Valerie Stanfield. The nomination of Justice Stanfield as Mr. Reed's response to the question from Senator Babbage was intensive and scrutinized closely. There are unique factors that Justice Stanfield brings to the job that makes her an excellent choice for the position of Chief Justice, and as Senator Carney also mentioned, as Justice of the Law Court. She, first of all, has experience in private practice. She was one of the pioneers, really, in the trial bar, women pioneers in the trial bar in the state of Maine. She had an excellent reputation, and candidly, it was not easy to make your way in the world in the trial bar in those days. And Justice Stanfield, then private practitioner Stanfield, developed an excellent reputation, both with the attorneys who were on the same side as her in cases and those who are on the opposite sides of cases. And her sharp intellect and intellectual acuity and her solid legal reasoning really kind of made her a standout in the trial field. That's an important component for the choosing of a Chief Justice of the Maine Supreme Court, because that person is the head of the judicial branch and makes the rules in conjunction with the rest of the judicial branch for the trial bar. And those rules are not only important for the trial bar, but they're important for the trial bar's clients, for the citizens of the state of Maine. And Ms. Stanfield, because of her experience representing clients from every walk of life in the state of Maine, understands the challenges that litigation brings, under challenges the court system brings to the citizens of the state that are represented by attorneys. That was an important component. The other important component and one that is somewhat unique, I think, to Justice Stanfield, is she also spent time in the world of academics. And when you're transitioning and going into an appellate court, the world of academics is one of the experiences that helps you develop in terms of legal reasoning, in terms of developing coherent opinions when you're going on to an appellate court. And her experience in the academic setting is, again, an important and in many ways unique component of Justice Stanfield's experience. And then lastly, but certainly not least, is her experience as a trial judge and trial justice in the Maine trial courts. We kind of had a unique vantage point, in a sense, with Justice Stanfield, because in interviewing other judges for other positions, sometimes questions would come up. Well, who else in the judicial system do you kind of emulate, or do you look up to, or do you go to for advice when you have a thorny legal issue? Many times, unrelated to this particular position, but over the years, the response to the question of the committee by other judges was Justice Stanfield, that she was a resource for newer and experienced judges to be able to help them through the thorny legal issues that they would grapple with at the trial level. This obviously makes an impression on the committee. So when you put all those factors together and you look at the times that we're in terms of the challenges of the pandemic and the challenges going forward in terms of providing justice for the citizens of the state of Maine in an increasingly complex environment, Justice Stanfield brings the intellect, experience, and compassion as a person to that position. For those reasons, on behalf of the committee, I ask this committee to act favorably on the nomination of Justice Stanfield to the position of Chief Justice of the Maine Supreme Court and as Justice of the Maine Law Court. Of course, I'd be happy to answer any questions.
Thank you very much, John Hobson. Committee members, are there any questions? Go ahead, Senator Kime.
Thank you. Thank you for being here, Mr. Hobson, and thank you for that testament. I was wondering if the committee looked into how many of Judge Stanfield's cases have been appealed and whether or not there's a higher rate of appeals, speaking specifically around parental custody issues, which I know are always thorny and often appealed, but just wondering what the background research was and what was found out there.
The short answer is that we did do that. Look, I cannot tell you off the top of my head the number. It was very, very few, where she was overturned by the law court. And Justice Stanfield probably can give you the exact number. But from the committee standpoint, her record on appeal was extraordinarily good.
And whether or not there was more, just to clarify, whether or not there were more appeals than with others, that's not something that you would have considered, just whether or not they were overturned. Is that right?
I think primarily the emphasis on whether or not they were overturned, whether her opinion was correct. I do not remember a statistic in terms of number of times appealed. So I'd have to tell you that I don't remember that as being one of the criteria. It may have been a number, but the one that obviously that we focused on, at least that I remember focusing on, was as one factor among a number, was her how often she was overturned in appeal, whether she got it right.
Thank you.
Committee members, are there any additional questions? Not seeing any. Thank you so much, John Hobson. The chair now recognizes the Honorable Valerie Stanfill for the purpose of making a statement concerning this nomination.
Thank you, Senator Carney. Good morning, Representative Harnett, Senator Carney, and members of the Judiciary Committee. My name is Valerie Stanfill, and I live in the lovely Kennebec County town of Wayne. I'm deeply honored and humbled to be nominated for Chief Justice of the Maine Supreme Judicial Court and Justice of the Law Court. I especially thank Governor Mills for the trust and the confidence she has placed in me. I'm pleased to have the opportunity to appear before this committee concerning my nomination. Although originally from away, I have lived in Maine for just about 40 years, and my family spent summers here for more than 100 years. My father and stepmother are able to watch this hearing from Arizona because we're on Zoom, and other family members are spread across the country and also can watch. Even though from away, my family's connection to Maine runs deep, and it spans the generations. I don't have children, but my nieces and nephews are now young adults, and they return here every year just as I did when I was growing up. They too love the outdoors and the beauty of this state. And outdoors is where I spend my spare time. I'm afraid I'm somebody who used to teach skiing and used to lead whitewater kayaking trips. Now I'm a little bit more genteel. I tend my garden, paddle on the lake, and spend time in rivers and in the woods. This is my fourth time in front of this committee. In my first hearing, I know I asked you to confirm me as a district court judge. I was so nervous, I don't actually remember what else I said, although perhaps some of you do. In my second confirmation hearing, I asked to serve a second term as a district court judge. I reported I had learned how much more it takes to be a judge than to simply decide the case. All that we do in court and in life, but especially in the courtroom, is informed by the words of Plato: be kind, for everyone you meet is fighting a hard battle. The last time I was here was about 1.5 years ago, and I had been nominated for the Superior Court. I emphasized at that time that I had more than 3 decades of trial experience, including jury work. I told you that I thought I had not only the intellectual skills required for the job, but also the empathy and the compassion to ensure that people who come to court are treated with fairness, respect, and justice. And so I come before you again with a record of over 14 years as a district court judge and superior court justice, together with more than 20 years of experience as a lawyer and law professor before that. This time, I'm asking to be confirmed as Chief Justice of the Supreme Judicial Court and Justice of the Law Court, the highest position in the court and the head of the third branch of state government. I expect you have many questions for me. In particular, you have every right to ask, why should that position go to me? And I'm going to do my best to answer that. As a youth, I didn't know what I wanted to be: a doctor, an architect, an engineer, a mathematician like everyone else in my family. Unlike many girls growing up in the 60s and 70s, I never thought there were limits on what I could do. I just didn't know what it was. I went to liberal arts college majoring in history with a non-traditional emphasis, but I still didn't really know what I wanted to be. And then I went to law school. I loved law school, and I found I loved the law. As you heard, I worked a summer at Norman Hansen in Detroit at a time when Representative Moriarty was a young lawyer and there were no women there amongst the lawyers or law school interns. Working with Peter Detroit, I was privileged to spend time with the late Caroline Glassman. shortly before she was nominated to be the first woman on the Supreme Judicial Court. I also worked for a year as a student prosecutor in the Cumberland County DA's office. And so, while in law school, I found I not only loved the law, I also loved the courtroom. I clerked for the trial courts, and then I joined a law firm where I'd be a trial lawyer. I handled all kinds of cases, civil and criminal. The primary theme of my work there was that we represented real people in court. I became a partner after but a few years and was in fact the only female partner during those years at my firm. It is thankfully, by the way, very different now. As valuable as that experience was, however, I did want something different. In 1999, I was invited to come to the University of Maine School of Law to supervise the Cumberland Legal Aid Clinic students over the summer. That summer invitation extended into 6 years. In addition to supervising students at the clinic, I taught trial practice and advanced trial advocacy, as well as some independent studies. In 1999, utilizing a grant from the Violence Against Women Office, I started the Domestic Violence, or it's also known as the PFA Clinic, which continues to operate to this day in the Lewiston District Court. In 2003, I was able to create another clinical program providing civil legal assistance to prisoners, program which also continues today. In 2001, I was asked to step into the role of acting director of the clinic at a time when it was in crisis. As director, I regularly worked with some other community partners, including the Maine Bar Foundation and the Justice Assistance Group. And I was responsible for obtaining and administering grant funding for the clinic. I also worked together with directors of Maine's other legal service providers on other projects. And I think it was already mentioned, but one of my proudest accomplishments came after a conference suggestion that we should consider joint fundraising. I thought this was a great idea, but no one else actually did at the beginning. No one else agreed. But I was able to persuade the other organizations to unite together to create Maine's successful Campaign for Justice, the statewide coordinated annual campaign to raise funds for legal services. And I served as the first provider chair for that campaign. During my time as a lawyer, I was active in many organizations, and my peers did often ask me to serve in leadership. I was the first woman elected as president of the Androscoggin County Bar Association. I was chair of the Fee Arbitration Commission of the Board of Overseers of the Bar for a number of years. I was co-chair of the Women's Law section of the Maine State Bar Association. I was on the Board of Governors of the Maine Trial Lawyers Association for a number of years. In fact, I was an officer in line to be president of the organization when I was nominated to be a judge. And I served on other boards and with other organizations as well. As much as I enjoyed my time on the law school faculty and working in legal services, and particularly enjoyed working with law students, I really didn't want to continue as clinic director. I stayed on for a year to help with the transition after we hired Professor Deirdre Smith, whose able hand continues to guide the clinic today. In fact, it was Professor Smith who put me on my current career path. At the time, she served on the Governor's Judicial Selection Committee and urged me to apply to become a judge. And the more I thought about it, the more I thought, well, that might be the right choice for me. And it was. Put simply, I love being a judge. I'm now in my 15th year, and I'm still grateful every day for the opportunity to serve the people of Maine. I strive to be respectful and hardworking in the courtroom. I try to have clear and thoughtful analysis while demonstrating compassion and vision in my written opinions. I believe I am respected by my colleagues, and in fact, I've been a mentor to other new judges. As a judge, I've also served on commissions and committees inside and outside the judicial branch. And because of that, I've also had the opportunity to work with a variety of stakeholders and address some broader public policy issues. Through that work, I've continued to demonstrate, I think, the ability to collaborate, to bring diverse interests to the table, to solve problems. I also relish the thought of continuing to decide cases, judging, but moving on to the larger stage, where the analysis and decisions impact not only the immediate litigants, but also other cases, present and future. I'm passionate and knowledgeable, I think, about some of the immediate issues facing the court system today. Those include, of course, indigent legal services, issues regarding criminal pretrial reform and sentencing, issues of systemic racism or bias, which include gender and cultural issues, and overall, the backlog and the stress that have been created by the pandemic. I believe my years of practical experience, first as a lawyer in private practice, as a professor at the law school, and now as a trial judge at both trial court levels, have helped me understand the impact of appellate decisions on people's lives. Indeed, the fact that I currently serve as a trial judge, I think is an advantage in addressing important issues that the judicial branch faces. As a trial judge at both the district and the superior court levels, I've been in the trenches, have been able to observe what has worked well, particularly in dealing with and adjusting to the impact of the pandemic on our systems. As a trial judge, I preside over criminal jury trials. Well, I used to, and hope we will again. At the beginning of every trial, I pause in the face of the enormity of the undertaking. I listen to our words to the jury after they've taken their oaths, words that haven't changed in centuries. We say, members of the jury, hearken to the evidence. You are sworn well and truly to try the issue. For trial, the defendant hath put himself upon this country, which country you are, and which country we are, and which country we all represent. How privileged we are to be part of this. Socrates said 4 things belong to a judge: to hear courteously, to answer wisely, to consider soberly, and to decide impartially. I try to live up to those ideals every day. I'm dedicated to the law, passionate about ensuring meaningful and equal access to justice for all. These are the core values and strength of the American legal system, a system essential to a free society. If confirmed, I would not be the first woman in Maine to serve as Chief Justice. That distinction, of course, belongs to the Honorable Lee Ingalls Softly. But I would be the first woman to serve as Chief Justice who harvested a moose, a deer, and a turkey in 1 year. I can imagine no greater honor, calling, privilege, or responsibility than serving as Chief Justice of the Supreme Judicial Court and Justice of the Law Court of this great state we call home. I promise you that if confirmed, I would serve with the utmost integrity and commitment to the administration of justice in the state of Maine. Thank you for the opportunity to speak with you, and I'd be happy to take any questions.
Thank you so much, Justice Stanfill. The chair would ask if any member of the committee has questions for the nominee. Representative Babbage.
Thank you very much, Madam Chair, and welcome, Justice Stanfill, and congratulations on this nomination. This is a wonderful day.
Thank you very much.
I wanted to ask you to reflect, really, on your socioeconomic background, how that impacted you in your formative years, and how your personal goals may have, what they were as a young person, and how they've evolved to what your priorities are today.
Sure, it's a good question. I was very lucky. I grew up wanting for little. I came from a background of parents who were professional, who had attended Northwestern University, indeed grandparents that had attended college and university. I think given my age, that's somewhat unusual. It never occurred to me not to go to college, for example. And there were no limits placed on what I could do. But I did definitely come from that, that suburb and, wanting for little. I was lucky over the years to have some different experiences. And college in itself was a bit of an eye-opener. And then I actually worked my way through college for not for all of the costs, but I had to work for a lot of the time. And I always worked in food service and worked as a bartender and waited tables. And I'm actually very good at that. And continued to do that after law school as well. And in fact, I took a little bit of time off and I taught school in the Lake region for a year before I went to law school as what they called a full-time substitute teacher. So I had kids, I primarily did middle school age. And so throughout those years, I was able to interact, I think, with different people and have different experiences. I lived in Center City, Philadelphia for a couple of years, things like that very much influenced me. When the then district attorney at the, when I was a law student, when I applied to work in the district attorney's office, because these weren't the things you were supposed to do if you were a top student. And he said, how can you do this? How can you relate to these people? And my answer to him was, I worked as a waitress in downtown Philly for a number of years. I promise you I can do this. And I think I can. And I think that since then, I've had a lot of experiences working with, as I said, real people and a different socioeconomic that has really had a lot to do with my experience. I had college interns when I was a judge. And one of the lessons I always wanted them to take from the experience was to see the people who are coming into our court, the struggles that they are facing, to have empathy for them, to understand that it's not easy and that they are struggling in many instances to do the very best they can, even if it's not what somebody from a different background thinks should happen. So.
Thank you. Thank you very much.
Representative McCreight.
Thank you, Madam Chair. Thank you, Justice Stanfill, for your words. A couple really stood out to me. One was listen, and another was empathy, which you just mentioned again. My question is, I'm curious about the training that judges have to do the work that judges do. And I'm sure there isn't enough time to do as much training as people would want. But could you talk a little bit about what kind of training judges have when they go into it and what the ongoing training is, and whether it's changed over time as situations and life changes? Thank you.
Thank you. It has changed over time. Not surprisingly, many years ago, I think new judges kind of came on the bench and were told to go sit in the courtroom and have fun. But we in this state, our district court judges in particular, and also superior court justices, have an incredibly broad areas that they work in. It's everything. They are essentially judges who are general practitioners. And by the way, that's not typical. Having been to some national conferences, most judges in other states, certainly bigger states, their jaws drop when they find out, the kinds of cases that our judges have to handle. What we do for a training program now for new judges is a combination of shadowing and practical experience and sort of, if you will, classroom experience. And we tend to try to, so the classroom module might be, for example, I taught new judges issues regarding protection orders and domestic violence for quite a few years. And so we'd spend a full day with training materials and talking about those issues. And then the attempt is to get them onto the bench to shadow an experienced judge doing those kinds of cases, and indeed to do their own. It doesn't always work completely perfectly that your day on the protection orders on the bench is going to follow immediately your day in the classroom, if you will, but we try to do that. So we have different modules covering obviously everything from criminal law, criminal sentencing, domestic violence, family law. They're taught by other judges, by family law magistrates, and in some cases, even the criminal process manager and things like that. So that process extends for, I think, a month or 6 weeks or so of, sort of real training. And then at that point, again, they'll be sent out usually to areas where they're not ultimately going to sit, because we like to make our real rookie mistakes away from our home courts. And that's the basic process for training new judges. We also do continuing judicial education in-house primarily these days. Sometimes we bring in outside speakers. We do that at Judicial College in the fall during the administrative week for all judges. We have, for example, the Court Improvement Project, the grant for child protective training in the spring, usually every year. And there's other opportunities like that as well. Right now, we're doing some in-house modules on, particularly with regard to biases and racism. So hopefully that answers your question.
Representative Poirier.
Thank you very much, Madam Chair, and thank you, Justice Stanfill, for coming and being with us today and allowing us to ask some questions of you. In looking over the information that was provided to the committee, I did have a question regarding a controversial case that you presided over regarding a decision that you made for a do not resuscitate order on a young child. And I was hoping that you could tell me about the case and how you decided the constitutionality of taking away healthcare decisions from the parents and giving them to DHS.
I'll do my best. It was a while ago and I haven't read my own decision in quite a long time. The issues that I addressed in that decision have since been replaced or informed by a statute. At the time, however, there was not a statute that gave me a great deal of guidance as to what to do. What I did actually quite a bit of research in that case on a national level to figure out what were the best standards to be. The problem in the case was that this was very early on. So we weren't at a stage of terminating parental rights, which is when obviously one would expect that kind of decision-making to be taken away from a parent. And so what I did is I looked at what other states had done. I looked at, frankly, read quite a few law review articles and the like. The parent also presented a pediatric ethicist as a witness, who also set up a decision-making tree or rubric to be used. And I think what I did is I ultimately applied the highest possible standard consistent with child protective cases that the state would have to prove in order to have that decision taken away, if you will, from the parent at that stage of the proceeding. And as a factual matter, one of the important points was that she was not engaging with the treatment providers, nor, and so as an example, that is some of the kinds of factors that would go into it, because what we're talking about is making informed consent for medical decision-making. So I think that's the kind of analysis. It was a very difficult case. It was very sad. And I want to say that I felt that because it was widely reported in the papers at the time, I felt terrible for the mother who had frankly done the best she could.
Thank you for the response. I appreciate it.
Let's see, Representative Moriarty, I think you're next.
Thank you, Madam Chair. And good morning, Justice Stanfill. You've done an excellent job in summarizing your diverse legal and professional background, and you're having covered all of those bases. I guess I have no choice but to descend to some of the nuts and bolts of what you are about to encounter. Much of your work is going to be administering the judicial department. And we all know what we've just come through over the past 15 months. In at least the short run, what do you see in terms of reopening the criminal and civil jury trial process to alleviate the backlog?
I think at this point, the criminal jury process is opening up. We've successfully held jury trials in a number of the counties in this state. I think it's, certainly in Androscoggin, we've done it. We've done it in Kennebec, Penobscot, Cumberland, I believe in Waldo as well, or in the month of May. And I think coming now in the month of June, Oxford's going to be holding jury trials. I mean, I think it's going to be spreading throughout. I think with the changes in capacity limitations and some of the other things that are happening, we'll be able to open up in some of the counties, which was much more difficult to operate under those limitations. Some of our smaller counties only have one courtroom, and it's not necessarily very big. And so it was a little bit difficult to envision, with some of the limitations we were all operating under, how we could do a trial in those counties. However, I think that's really changing now. So I expect we'll be pretty soon back to, fairly full steam ahead on jury trials, at least in the criminal arena. Now we have to work in the civil arena as well. So I think I expect we'll start to see civil, but these are discussions that are ongoing, and obviously final decisions on the best way to proceed. I expect that's one of the tasks, if confirmed, that I'll have to address, obviously.
Sure. If I could just follow up with one more question. Given the fact that new civil and criminal cases are entering the court system continually, is there any projection within the department at this point as to when we might get back to the even balance that we enjoyed prior to the pandemic?
The short answer is no, I don't have a date. I think that cases have continued to be resolved. It's been surprising to me, and I've heard this from civil practitioners as well, that even without imminent trial dates, cases do get resolved. And I think as we start to have more trial dates, that's human nature, event certainty. If people know that they have a trial, they get a little more serious about seeing if the case can be resolved or not. But I don't have a date. I think it's hard to say at this time. And I will say that although jury trials in civil areas weren't held, motion practice and other things continued to happen. And certainly some, civil non-jury has occurred, as well as all the written work. So it hasn't been at a complete standstill. The standstill has been at the jury trial end. And same in the criminal arena, of course.
Sure. Okay. Thanks very much.
Representative Harnett?
Thank you, Madam Chair, and welcome, Justice Stanfill.
Thank you.
And thank you for your introductory comments. Because you have been before the committee, as you mentioned, this is your fourth time, I was able to go through your prior submissions, and I've always been struck by your answers regarding mandatory sentences and fines. You mentioned that mandatory fines are often imposed on the people that are least able to afford to pay them, thus sometimes leading to the criminalization of poverty. And with respect to sentences, you mentioned that mandatory sentencing can put too much power in the hands of prosecutors, resulting in backroom deals, in plea bargains, and keeping things from out of the courtroom, thus losing focus on the individual who's been charged. Have your views on that changed over time? And could you expand on how those might impact you as the Chief Justice of the Law Court?
My views really have not changed. In terms of, there are some of those things are completely without my control. They are in your control as legislators. In other words, things like mandatory sentences are what they are. And they often can provide guidance. I'm not suggesting it's a bad thing. It certainly has informed, I think as a judge, it informs sentencing decisions, that this is viewed as incredibly serious, or when there is a significant mandatory sentence and things like that. But it does, an obvious example would be, for example, aggravated trafficking or a trafficking charge based on the amount, which carries a mandatory 4-year sentence. And if the parties agree that maybe that's not appropriate, the negotiation occurs in changing the charge, right? Because otherwise there can't be less than a 4-year sentence. So that's what I meant about driving it, for those of you who haven't heard those comments, about driving it into the hands of the parties and the prosecutors and outside of the courtroom, because the pressure then becomes to change the charge, to get out from under that mandatory sentence. So there's a little bit of dishonesty, if you will, in the way that we deal with that. And fines, and we've been given more flexibility over the last number of years in terms of the ability to make fines non-cumulative, or to indeed suspend some of fines that are at least on their face mandatory. But the fines can really add up for people. There are people that owe thousands of dollars and they're struggling to find, they don't have homes and they owe thousands of dollars in fines. So I think as judges, we have to continue to be aware of the issues that are in front of us when it comes to sentencing. We apply the statutes as they are given to us. We apply them hopefully fairly. I think, sentencing guidance is not a bad thing, but those are the issues that I see as a judge.
Thank you. And one quick follow-up,
Sure.
Madam Chair. You used the word when you focus on changing the charge that it can appear to be a dishonest process. Would you also agree that it eliminates transparency in the judicial system?
It does, and that's what I meant by that. Is it puts it, so there are commentators who would say that it's put it in into, I think I just did something very strange to my Zoom. There are commentators who would say that it puts it in the back room instead of in the open courtroom. The discussion about sentencing has to necessarily occur in the back room instead of the open courtroom as a result. So that's what I mean by that. It's not really dishonest. There's nothing wrong with it. I think our prosecutors and our defense counsel are doing the very best they can to reach a just result. I'm just saying it puts it outside of the courtroom instead of inside of the courtroom to talk about what the appropriate sentence is in a case.
Thank you. Thank you.
Thank you very much. And Representative Reckett, you're next.
I'm trying to go through one entire day without somebody having to say to me, "You're muted."
I'm struggling. All of a sudden, I have this little tiny thing. I don't have a big picture anymore, but that's okay.
Anyway, it's good to see you again. And although I think I haven't actually seen you in person for some time, but I feel I feel prejudiced in your favor as a result of our 10 days in Russia together back whenever that was, and where I think I got to know you a little better, and vice versa, I'm sure. I wanted to ask you about a question that spins off of my admiration for the Volunteer Lawyers Project and my devastation when their director and dear friend of mine about a year ago passed away. My question for you is, what do you see as the future of not just the Volunteer Lawyers Project as an entity, but for that initiative statewide in terms of the organizing or the continued organizing of volunteer lawyers to assist with cases particularly in the district court?
Well, I too miss Juliette Holmes-Smith. I mean, the former director of the Volunteer Lawyers Project, and she was wonderful and brought a wonderful energy to it. But I think that it will survive. And they continue to, volunteer lawyers continue to provide services. In fact, I was in the Lewiston District Court, I think it was last week, and there were volunteer lawyers there that day. So they'll continue to do so. The Maine Bar has been historically incredibly generous with their time through the Volunteer Lawyers Project, and for that matter, individually and on their own, not in a no formal way. So I have high hopes that that's not going to change.
If I could just follow up in, It's not exactly a direct follow-up, but my other area of concern in the courts at the moment are the training and utilization and the competency of the guardians ad litem. And I continue to be not 100% thrilled with what goes on in that arena. I couldn't tell you a specific instance. It just, every time I get near it, I get nervous. So I think that my question is, how do you see that body of mostly lawyers or social workers trying to do that work? How can the courts make them a better informed cadre?
Well, I think we're always trying to improve the training that we give. And as you know, there have been improvements, I think, over the last number of years in terms of how things can get reported, whether a guardian is upholding the ideals of what we want them to uphold and the like. It's imperfect. I know there are people who would say that guardians ad litem have too much power in cases. I never found that to be the case, but they are incredibly valuable both in what we call Title 19A, the family law cases, as well as Title 22, the child protective cases. My view of it as a judge was always a good guardian ad litem raises the issues for me. I was a little bit famous or infamous, I'm not sure, on the district court for not following what the guardian recommended in the end. But I always felt that they did a good job if they raised the issues for me, and that's what we're looking for. The training, I mean, we try. I think we cover a lot of areas. As you're probably not surprised to learn that there have been years in the past where I was part of the domestic violence training for guardians, for example, and the family law and its intersections there. But it's a tricky area to talk about that. And we have so many areas we have to train them in, and only so much time to do it because many of them are doing, well, the training itself, they're not getting paid, obviously. So I think, always want to hear ways of improving a system. We've got some incredible guardians out there and some who aren't so good. I think, as judges, you often know who they are.
Yeah. I've often thought that the ideal guardian is not a single guardian, but a combination team of a lawyer and a social worker together, trying to figure out what the case is. And of course, then you're adding more money. But I often thought that those two pieces need to be part of that process.
There are states where there are, even within the judicial branch, almost in a sense like case managers or guardians in every case. So.
Thank you very much, man. I wish you well.
Representative Babbage, I think you're next. Is your hand up anew?
It is, Madam Chair. Thank you. Justice Stanfill, I downloaded so much and read so much, and yet in the short amount of time we have, I'm actually drawn to more reflective umbrella questions rather than the specifics of certain cases. Maybe that will be a relief. I don't know. But I wanted to, in the classroom years ago, I remember on occasion drawing on a conversation between Oliver Wendell Holmes and I think it was Leonard Hand, who, as they departed, Holmes was in his carriage about to leave, and he said, "Do justice, my friend." And Holmes stopped short and said, with a pointed finger, I believe, our task is not to do justice, but to do the law. Are they mutually exclusive? I wondered if you had any reflective comments about the philosophy of jurisprudence here as you bring it to the court.
Well, I think that's an interesting. They're not mutually exclusive by any means. Perhaps they do not always perfectly line up. I think I bring a pretty disciplined approach to the law. When I was taught at the law school at the clinic, I was known as the rules queen. Okay, there's a part of me that is very, and when judges come to me, I think, or other people come to me, my first question to them is, what does the statute say? What does the rule say? On the other hand, we need to look at those with an eye toward the bigger picture and justice. And oftentimes there are different ways of applying rules or laws. There may be different meanings. There may be conflicting, you could go one direction or you could go another. And so I think our job as judges, our best and highest job is to make sure that we apply the law, that we are disciplined in our application of the law, but that indeed results in justice. That is our best and highest use.
Thank you for that response. If I may, Madam Chair, Justice Stanfield, I'm a non-lawyer here, and unlike some of the people on the committee who do the lawyerly thing by knowing the answer when they ask the question, I'm actually asking from ignorance. So, I wanted to ask what you would bring to the court regarding, I'm more familiar with the Supreme Court of the United States as far as procedure, but let's talk about certiorari. What is a solemn occasion and all of that? Are you familiar with that process, and what would you bring to it as chief?
Well, writs of certiorari are really more of a U.S. Supreme Court
That's right.
discretionary. It's a writ for a discretionary review. There are some areas where our review is discretionary in our main law court, but a lot of it is not. But the majority of appeals that are done, it's an appeal as of right. So there's not a lot of discretion in that respect. The solemn occasion language that you've used is another function of our Supreme Judicial Court in doing things like responding to a request for an advisory opinion from the legislature, which one of the requirements is that it be a solemn occasion and serious question. In other words, we don't want to just sort of lightly have to have courts giving opinions to the legislature all the time. You should be doing your work. But it is permitted under our constitutional system for our Supreme Judicial Court to give an advisory opinion, which in many, including the federal system, is not permitted. In the federal system, you have to have a case or controversy. We, on the other hand, in Maine, have the ability to have our court, our highest court, give on a solemn and rare occasion an advisory opinion. So I think that's the.
Can you clarify to me what your role as chief might be versus as a collaborative administrator?
I think when you're on, well, chief, when you're talking about the court, you're really just one of 7. As far as I am aware, and I am sure that the other justices on our law court all are experienced and good and excellent and smart judges. And that process is always a collaborative one. I think the broad shoulders are more necessary, if you will, on the administrative side.
Thank you for that. I appreciate it. Thank you, Madam Chair.
You're welcome. Senator Keim, go ahead.
Thank you, Madam Chair. Hello again, Justice Stanfield, and congratulations on this nomination. I wanted to follow up on what Representative Poirier was asking you, and I think you mentioned you weren't maybe not remembering the case that well, but it was something that you had mentioned in the information that was given to us for your most recent nomination, the case of the parental rights with the DNR that was allowed to be placed on the child. So parental rights is a very, very important issue to me, and of course something I think that will be coming to the law court because all of our most basic and constitutional rights, I think, make their way up there because that's where the appeal goes. So I did want to hear some more specifics about how you decided that case against the parent and for DHS, because one comment you made was that the mother did the best she could. And so you said that, and yet then you also sided with DHS. So I was trying to understand how that decision was made constitutionally and try to kind of dive into that a little more to understand your perspective on parental rights.
And to be clear, I remember the case. I remember the people and I remember the case. I have not reread my opinion and the precise legal decision tree that I set up. I did take, after researching it across the country, I did take what I thought was the most stringent standard. I required, first of all, proof by what we call clear and convincing evidence, rather than simply by a preponderance. Ordinarily, in our child protective cases, the only issue in the ordinary child protective case, which requires proof by clear and convincing evidence, is the actual termination. All other stages are governed by a lower standard of preponderance. So one of the things I did is I decided this was such an important and fundamental issue for a parent that it also should be governed by that higher standard of proof, the clear and convincing standard. And that essentially, even though it was in the early stage, in order for the decision that medical decision making, the ability to say, we're going to have a DNR order in place, in order for that to be delegated to the state and taken away from the parent, that the state would have to prove essentially the grounds for termination. Now, termination of a parental rights ordinarily does not occur until there's been time. And so that's the element that is missing at that stage, but it still had to be the same elements as far as I was concerned of a parent who was unable or unwilling, but unable was really in the situation to make the decisions and to take care of that child at that time. And unable to make decisions when it comes to that particular area, to me, meant unable to make an informed medical decision because she wasn't participating in the medical decision making. So that's, I think I did the best. I think I did protect parental rights. I agree that they are fundamental. I think, child protective is a difficult area because obviously these are confidential cases. The only reason I've been comfortable even saying as much as I did about that case is frankly, it was widely reported in the newspapers. But I think that I did a lot of child protective cases. That goes to the question about how often I'm appealed. Those cases, when they do involve termination of parental rights, are routinely appealed. Mm-hmm. And I did a lot of them. So, I think it's fair to say there were a number of occasions where, I certainly found in favor of those parents and did not terminate rights despite what a guardian or despite what the state wanted to do. So I think I'm a firm believer in parental rights as well.
Thank you. Yes. And then the other thing you mentioned is that the law had changed around that actual situation. And I was wondering if you could tell me how the law has changed and if that would have changed any of your decision-making in that case.
On that particular case, there is now a law. There wasn't a statute in Maine that governed that situation. When I had that case, there now has been an amendment and it is in Title 22 as to what the factors would be when that kind of important decision could be taken away from a parent prior to termination and delegated to the state. And it essentially, my decision would have been the same under the new statute. That's because I think like I say, I think I applied about the highest, looking at the different options and what other courts.
And it was, and so the statute is specific to healthcare decisions?
Yes, there is now a statute.
Very good. Thank you so much.
Let's see, Representative Moriarty, you're next.
Thank you, Madam Chair. Justice Stanfield, we were talking a moment ago about the backlog, particularly with reference to jury trials. I want to just expand on my question a little bit because I know that the system as a whole is severely backlogged in every aspect. Do you see an increased role for active retired judges to help alleviate the situation? And if so, how do we lure them back? I guess part of that also was whether the limitations of our courthouses themselves would preclude increased participation by the active retired from really making a dent in the problem.
Yeah, it's a good question. First of all, I want to correct one thing. Not all dockets are actually backlogged right now.
Ah, good to hear.
Or certainly not at all stages. I, in fact, had made inquiry, at least locally where I sit. I'm currently in my chambers in Auburn, as to the status, and talked to the clerks. And actually, some of the dockets are not very far behind. And even in the criminal arena, which is what I've obviously been focusing on for the last, 15 months, what's behind are the jury trials, but not all the other stages, everything else. So that I think there's a bottleneck at the jury trial stage there. And there are some dockets that are very behind. Now there are some dockets that haven't been held from, limited small claims, et cetera. But and that's one part of the question. The other part about active retireds, yes, of course. I think that is one way, obviously, we can perhaps sort of put on a really good push to get some of these cases done, particularly for non-jury areas. That might be very helpful. Small claims, the disclosures, things like that. With regard to jury trials, it may be helpful to be able to call on active retired. We have some incredibly wonderful and experienced jurists. But at the same time, that is far more limited by facilities and by staffing. It's, as you can imagine, conducting a jury trial is also has a bigger impact on, it takes more marshals, it takes clerks, so we can only go so far, I guess I would say, on that. And I think that's something we have to look at. But the limitation in terms of trying to ramp up jury trials is not so much actually on jurists, particularly if we can call on active retired, but more on facilities and staff.
I said, okay, thank you.
Representative Babbage, did you have a final question or is your hand residual?
Well, I'm sorry. If there is not another question, I would like to ask one more, if I may. I do want to. I appreciated your personal comments at the beginning. I want you to know, Justice Stanfield, that on one visit to Philadelphia, I did do historical research at McGillen's, but I wanted to ask you about the concept of clearly established right standard. Are you familiar with that regarding qualified immunity? Because this issue is one that is really defined through judicial case law rather than statute, I think. And I hadn't phrased my question here, but I was hoping to get a better understanding of the clearly established right standard that courts seem to defer to in questions of qualified immunity. Have you ever had anything before you like that, or in your personal?
I actually had handled a number of cases involving those issues as a lawyer, but I have to tell you, that's been a long time. You're correct. I think what you're getting at is in most, there is a doctrine that says that when it's a discretionary function, that there can be qualified immunity if the conduct doesn't violate a clearly established right, of which a reasonable person should be aware. I think that I'm not sure what the question really is beyond that, I think that that's an area that legislatures are wading into. And I think, I don't know if this legislature is, But I'm
Yes,
not.
I guess what I, and you know, and I think, and things that may become before you, I realize you probably want to be careful with, but I wanted to, the established, clearly expressed right doctrine has been arrived at judicially rather than legislatively, I think. And that's, if there is to be change, it would not, if you rely on precedent, then that change will not come through the judiciary. Is that right?
Well, to some extent, I mean, obviously precedent can be overruled, although one would do so only, it would be unusual to do so. The doctrine has evolved both in state court, but also it's primarily a federal doctrine as well under Section 1983, civil rights actions and the like. So in state court, we wouldn't necessarily be, getting to that anyway. That's the primary area, or in the state legislature for that matter. I mean, I think that's the biggest area where we're seeing where it arises, the qualified immunity. I don't pretend to be an expert in this area. I want to be very clear about that. I'm just sort of pulling things out of the recesses of my mind. But it is fact patterns can be different. There is a judge-made set of rules. The legislature, if you choose to put limits on that, can do so. For state law, not for federal law.
Thank you. And I come to that question, not endorsing anything, but establishing that modifications would probably have to be addressed legislatively. That's what I wanted you to confirm, that it's kind of a judicial established doctrine at this time. And that's
to some
correct.
extent. There are some statutes on it as well.
Okay, thank you for that. Thank you, Madam Chair.
You're welcome. Senator Keim, go ahead.
Thank you. Justice Stanfill, I was wondering if you would talk to us about pardoning dogs and how, I know it's an easy one. So how was that decision made? Basically, I think as I read it, basically kind of to ignore the pardon and move forward as if that sort of hadn't happened. So I wonder if you could just explain that and tell me how that case ended up.
Sure. I mean, in a way, that's actually an example of what I talk about when I say, we can only decide what's in front of us and be disciplined about it. The pardon never actually came up in front of me. I knew it was in the newspapers, but it was never actually raised in the actual case in front of me. So I didn't ignore it in that sense. That what is in front of me as a judge is the case. And the parties to that case were the state of Maine prosecuting it and what had been the owner of the dangerous dog. And so when the governor issued that pardon, it wasn't part of the case. Then there were some people at some point did try to intervene. We have rules governing what's appropriate intervention. And in the end, we sort of never reached all the decisions because the parties were able to reach an agreement to pardon Dakota in a sense, and not have him euthanized despite, and to end the case that way. At the time, the statute said shall, under the circumstances of those cases. The statute also, I think, has been changed since then. But at the time, the statute said that that the judge shall order that dog to be euthanized.
And when you say it didn't come up in front of you, just to clarify, so the defense never said, here's a pardon from the governor and show you that actual legal paperwork. Is that what you mean?
Sort of. In fact, the pardon didn't occur until after the case, from my perspective, was over. There had already been a euthanasia order. The person had admitted it was a dangerous dog, agreed to the euthanasia order, and there was a euthanasia order. Then, because of things that happened outside of the courtroom, people, started scrambling around. And as I say, really pretty much the next proceeding that came in front of me was all of the various lawyers from many of whom were not actually parties to the case, with an agreement as to what to do with the dog.
Understood. Thank you.
Committee members, are there additional questions for the nominee? Representative Reckett, I see your hand. I actually would like to just ask a question of the nominee before turning to Representative Reckett. This has come up in a couple of different questions that committee members have asked you, Justice Stanfill. Could you please speak to us a little bit more at length about the different roles of the legislative process and the judicial process and where they interact and where there are limits and where there are not limits? We've seen that in quite a few of your answers.
Sure. I mean, obviously, there are two different branches of government with two very different roles. And the big picture is the legislature you are the ones who set policy, who pass the laws, and who really set the policy for the state. In the judicial branch, we work with cases. We decide issues that come in front of us and apply those laws. Where it gets a little bit grayer, of course, is if the statute is not completely clear, or as in our discussion about the parental rights case where there was no statute. Then as judges, we do have to figure out within the framework of laws that we have what to do with the case. We're not determining policy in the same sense you are, but we do have to figure out how to decide the case. And so in that sense, we have to have that framework. And obviously it in that sense is policy. But that can, of course, generally, other than constitutional, be overruled by legislative enactment. And indeed, it sometimes is. And I think that distinction is critical. We really have different functions. And I think they're both equally important. As I said in my remarks, in that sense, we embody the country and different parts of how we make this country work, but they are different.
Thank you for that answer. Representative Reckett, you can proceed with your question, and thank you for your patience.
I think I'll choose to pass on what I was going to say, and but it was not, well, maybe I won't, because now you'll wonder what in the heck it was. Basically, I was intrigued when you said that some of the people who worked with you gave you the moniker, the Rules Queen. And the reason I was amused by that is that when former Chief Justice Softly was being considered for elevation to the Superior Court, I came and testified sort of in opposition because all of my advocacy staff regarded her as the goddess of justice, and they didn't want her to leave the district court. So I thought it was sort of amusing that each of the presumably, apparently, probably the two women chief justices each came to the court with a moniker of admiration in a sort of strange and different way from the people who have worked with them in the courts. So I was just amused by that. So it's not really a question, I confess.
Okay.
Thank you, Representative Reckett. And at this point, I do not see any additional questions on part of committee members. Justice Stanfill, thank you so much for answering our questions today.
Thank you.
The chair will now take comments from persons attending this hearing who wish to speak for or against this nomination. Anyone who has a written statement but who does not wish to speak should have submitted the statement with the committee clerk or online prior to today's hearing. All such statements shall contain the name and residence of the person who prepared the statement. A copy of each written statement presented to the committee at this hearing will be made available to the nominee prior to the committee's vote, and the nominee will have an opportunity to respond to the written comment. Those who wish to speak in person registered with the committee clerk prior to the start of the hearing and will be called upon by the chairs, at which time they will be promoted to panelist status in the electronic meeting and can be seen and heard. When it is your turn to speak, please observe the following. State your name and place of residence before beginning your testimony. Only comments concerning the suitability of this nominee for this particular position are considered in order. All other comments will be considered out of order. After you are done speaking and there are no more questions from the members, you'll be returned to the attendee portion of the meeting and the next person will be called. At this point, it's just going to take me a moment to bring over our first speaker. And we will initially hear from Lee Softly.
I did it. Can you hear me?
We can hear you and see you. Thank you for being here today, and you can proceed with your comments.
Thank you for your patience with my technology. Every time I think I have it right down pat, it slides out from under me. Senator Carney, Representative Harnett, and distinguished members of the Joint Standing Committee on the Judiciary, my name is Lee Softly, and I live in Cumberland County. I currently serve as the Dean of Maine Law, and it is an honor and a privilege to speak to you today about the nomination of Justice Valerie Stanfill to the position of Chief Justice of the Supreme Judicial Court. To be clear, I am once again here in my personal capacity, and I don't represent the university system or the law school today. You know that the decisions of the governor, this committee, and the Senate, and in the appointment of Chief Justice for the state of Maine, represent very important responsibilities. Recognizing the importance of your decision, I appear here today for two reasons. First, to address the current components of the role of Chief Justice, and second, to testify in favor of the governor's nominee, Justice Valerie Stanfill. Maine's Chief Justices, as you have discussed this morning, have to fill three separate roles in the modern world. First, the chief is an appellate jurist, and exactly as Justice Stanfill said, the chief is only a first among equals, and similar to a jury foreperson, the chief has only one vote, as I was regularly reminded when I was on the losing side of a legal analysis. Second, the chief is the CEO of a 500-person organization, responsible along with the state court administrator for human resource oversight, facilities, budgets, technology, schedules, security, all of the public safety issues. And finally, the chief is the leader of one of Maine's three branches of government. The chief must communicate with the governor, the Senate president, the Speaker of the House on myriad administrative issues relating to the health, safety, and prosperity of this great state. And in this role, the Chief Justice must keep the rule of law, access to justice, and the needs of the public in mind in all aspects of the work. Interestingly, the Chief Justices that I have known have come from fairly diverse backgrounds. Chief Justice McCusick came straight from private practice, never having served on the court in any role. Chief Justice Wathen served on the Superior Court, but never on the very busy district courts. I served on both trial courts, but never served as a chief on either of the trial courts. So that brings me to the governor's nominee for this important role, Valerie Stanfill. As you've heard, Justice Stanfill has served with great distinction on both trial courts. She brings a wealth of experience and knowledge about the administration of justice in different counties and different courthouses. She understands how to work with clerks, with the bar, with the public, and she has a solid focus on the reality of justice as well as the logistics. Regarding her prospective role as an appellate jurist, as you've heard today, she's demonstrated her ability as a prospective jurist through her excellent writing and analysis, so much so that her judgments and orders were often shared among her colleagues. Regarding administrative abilities and the capacity to work with the administrative office of the courts to oversee all aspects of the delivery of justice, a Chief Justice needs to be inclusive, collaborative, open to criticism, but ultimately able to be decisive. For almost every administrative decision within the judicial branch, there will be strongly opinions on all sides. As you have heard, Justice Stanfill has the capacity to listen carefully, be guided by others who understand the challenges, and make a thoughtful decision, even when that decision will draw criticism. Finally, as a leader, Justice Stanfill has demonstrated a clear vision of justice in critical areas of the court's work, including, sadly, the never-ending challenges of the domestic violence docket and family disputes, and her work in the unified criminal dockets. That clarity will serve the state well as the courts grapple with the unavoidable backlogs caused by the pandemic, the challenges of providing open access to digital records with insufficient public funding, and the upcoming challenges that we cannot even envision today. That's what makes a great Chief Justice, and Justice Stanfill, I suggest, will fill that role very well. I'm pleased to support her nomination, and I would be happy to take any questions.
Thank you very much. Committee members, are there any questions? I'm not seeing any. Thank you for providing your testimony today.
Wonderful to see you all. Thank you.
And next we will hear from Beth Dobson. Beth Dobson, if you're able to activate your audio and video, I think you've joined the panel, and I hope you've joined the panel. May take her a moment to join us, so we'll proceed to another speaker and check back in with her briefly in a moment. Next.
Anybody give me clues, because my technology skills are limited, and finding my way to the place where I need to push the right buttons is. Do I just share the screen?
Nope, just hold on for 1 minute. I'm going to see if I can send you a request to activate your video from this end.
Okay, I have to start my video now.
Go ahead.
Okay. There we go. All right, thank you for your patience. My name is Beth Dobson. For the last 8 months, I have resided in Bethel, Maine, in Oxford County. Late in life move. I was resident of Cumberland County for 40 years, 40 years. From the beginning of law school, where I attended the University of Maine School of Law. Before that, I was at the University of Maine at Orono. And I will also disclaim or inform you that I'm from away. I was also not born here, but I came to Maine and have not left residency since I came to Maine to go to undergraduate school. I would second the observation that was made in the initial introduction of Justice Stanfill, that she is highly respected by her colleagues and has been a mentor to many. I knew who Justice, I think then Judge Stanfill was before I became a judge, but it was after I became a judge myself that I really understood and began to value her contributions, particularly in the areas, as a number of people have mentioned, of domestic violence. Her work prior to her appointment is very well known. And I mostly was gratified that I had the opportunity for a period of approximately 4 years to share the same region with Judge Stanfill at the time. And we shared the courtroom in Kennebec County both Waterville and Augusta fairly frequently. And at that point, I truly began to appreciate her attributes as a colleague and as a mentor. We became known in our region as the heart and the hammer. And Val is probably uncertain where I'm going with this, but I promise that I will not disclose which of us was thought of as the heart and which the hammer, because those terms symbolize two attributes that a judge needs to have. The hammer is obviously referring to firmness and fealty to the law, and the heart is referring to compassion in considering the individual circumstances of a particular case. Judge, I refer to as judge because she was then, but I will try to make that better and say Justice Stanfill was my gold standard in trying to determine what I should do. We collaborated in the sense that we talked about our cases. Here are the facts. Here's the law. I'm not sure how they mesh together well. And she would never criticize, but firmly guide instead. And often I recall the advice, the sound advice and the obvious advice, except when you're in the situation of read the statute or the rule. And in many cases, the whole statute. Some of our statute schemes are fairly comprehensive and complicated, such as foreclosure. And if you only read this part, you'll miss the part that it says 24 pages later, something else. So as I lost the benefit of her close everyday presence in Kennebec County and in Region 4 and moved to West Bath, I often ask myself, what would Val do or what would Val say? So I attest, and I know that others feel the same way, that she was a mentor and always ready to consult and never to be judgmental of your resolution of the case. You are probably aware, as you've heard of her background, that Justice Stanfill would have had many opportunities in the law. Many of them may have paid more money than what is currently available to the public sector. But she is doing this because it's in her blood. She is a natural. Colleagues are not the only ones who think so. Attorneys, staff in the clerk's offices also work well with Val and she with them. And there were many easier paths, but she decided that this is what she should use, her first-class mind. And I will say intellect, pragmatic nature, and being the thoughtful and committed person that she is to assuring that the people who appeared in front of her in the courtroom would be heard. And when I was in the same court as her and had many cases that might have had returned to court for a subsequent motion, and that would be most typically family law cases, I was glad that she wrote very good decisions that addressed the facts and the law in the case, that gave me a solid background to make a good decision when the case was in front of me. In short, she's an awesome colleague. She was. I miss her. She's open-minded. She's well-organized. She's collegial. And I wholeheartedly agree with Governor Mills' assessment in announcing her nomination that she has a vast intellect, sharp intellect, vast experience and expertise, and a commitment to administering justice fairly and impartially, and that she would make an exceptional candidate for Chief Justice of the Maine Supreme Court and the Supreme Judicial Court and the Law Court. And I would be glad to answer any questions that you might have.
Thank you very much. Committee members, are there any questions for Beth Dobson? I am not seeing any. Thank you very much for your statement today.
Thank you very much for having me.
And next we will hear from Deborah Bader.
Can you all hear me right now?
We can hear you. Welcome. You may proceed.
Thank you. Thank you to Senator Carney and Representative Harnett and the entire Joint Standing Committee on the Judiciary. My name is Dr. Deborah Bader. I live in Mount Vernon, Maine, and I'm a forensic psychologist by profession. And I'm here today in my personal capacity to make a brief statement to wholeheartedly endorse the nomination of Justice Stanfill for the position of Chief Justice of the Supreme Judicial Court and Justice of the Law Court. I met Justice Stanfill when we were both serving on the Domestic Homicide Review panel, and I was immediately impressed by her keen intelligence. I suspect anyone who first meets Justice Stanfill to be struck by her sharp intellect, her quick grasp of the salient issues, and her wisdom. As I got to know her, I also became aware of her consistently balanced perspective, even with respect to thorny topics, and her work ethic. She was no perfunctory member of the Domestic Homicide Review panel. Justice Stanfill's work ethic is a defining characteristic. When she engages with her full attention, preparation, and conscientiousness. Other defining personal characteristics are her generosity and her kindness. She is generous and kind when it's easy, but more importantly, she is generous and kind when it's hard. Without going into detail, I can say that I have witnessed her generosity firsthand. Justice Stanfill embodies the best of Maine in all its facets. She knows Maine issues, she knows Maine people, and she knows the Maine character. She is truly rooted in Maine, both personally and professionally. Not only did she attend and then teach at the University of Maine School of Law, but she is an avid participant in all that Maine life has to offer. She's an accomplished skier, kayaker, gardener, and all-around sports person. On a personal note, I am a Maine native, and if I were ever to find myself lost on a mountain in Maine, to quote Don Fendler, I would want Justice Stanfill by my side. As her friend, I am thrilled for her to have this opportunity. But much more importantly, I am thrilled for the people of the state of Maine. Her calm direction, clear thinking, interpersonal skill, and organized manner will successfully guide the Supreme Judicial Court of Maine. There can be no better person at the helm of the judicial branch. Thank you so much for allowing me to speak in enthusiastic support of Justice Stanfill's nomination, and I would be happy to answer any questions.
Thank you very much. Committee members, are there any questions for Deborah Bader? I am not seeing any. We appreciate you being here today.
Thank you.
And before I'm going to invite over Jim Burke to speak, and I would just ask those who are in the attendee space, because some people have arrived for our language reviews this afternoon. If you wish to be heard on the nomination of Justice Stanfill, please raise, and you're in favor of the candidate, please raise your electronic hand and keep it raised until you've been called on to speak. Thank you very much. And Jim Burke, you may activate your audio and video and proceed when you're ready.
Thank you. Yeah. Is it working? Yes. Senator Carney, Representative Harnett, members of the Judiciary Committee. My name is Jim Burke. I live in Pownell now, and I'm here today to speak in favor of the nomination of Valerie Stanfill to Justice of the Supreme Judicial Court and Chief Justice of the Maine Supreme Judicial Court. I've known Valerie since she started practice in Lewiston in 1986. We did school presentations on various Bill of Rights issues at schools in Androscoggin County and I think some in Oxford County as well. We would present a complicated and entertaining issue to the students. We would argue opposing sides and the students would change sides of the classroom during the presentation, depending on which argument they tended to agree with, and you'd watch them move back and forth as we batted things around. We'd end the session with the students' open discussion of issues, and we were always impressed at how seriously and thoughtfully these students would respond to the exercise. Valerie and I would regularly switch sides from class to class, since there was always merit in each position, but more interestingly, none of the questions had a right answer. We were teaching students how to analyze and think about complex constitutional issues, the sort of things you do as a judge. Valerie and I were officers. We were also each in our own time president of the Androscoggin County Bar Association. We served together on the main board of overseers of the bar fee arbitration panel. We are both dog people, and I consider her a good friend. For a number of years, she taught women how to ski at the Lost Valley Ski School in Auburn with the aptly named program Chicks on Sticks. She is a fly fisher, and it is from her that I learned about fly rod Crosby. And she makes a wicked good wild goose chili. I won't recount her legal skills and background. You've heard about that today. You have it in front of you and others are talking about it. We all know she's highly skilled. The job of being Chief Justice of the Maine Supreme Judicial Court is not just about being a great lawyer or a great judge. It's no secret that most lawyers and most judges are not good managers of a business, are not good leaders of groups of people. We're independent sorts. And the primary job of the Chief Justice is, in fact, to manage and lead Maine's judicial branch. It takes very particular skills. And Valerie has all of those. She's not just a great lawyer and a judge, but she has the scope of vision, the grasp of organization, the strategic thinking, planning, patience, and diplomatic skills to successfully lead the judicial branch. It's a very hard job, and she's the person who can best do it. I've been a lawyer since Armand Dufresne was the Chief Justice. I've known in varying degrees each Chief Justice since then. I've brought 23 law court cases and 3 First Circuit cases in my career. I've taught students from 2002 to 2019. I think I have a pretty good idea of the work and the challenges a Chief Justice faces. Valerie can meet all of those and meet them well. I'll close with 3 examples of her administrative acumen and leadership. At the law school, she established the relationship among the clinic students, the Androscoggin Domestic Abuse Agency, known as Women Unlimited back then, and the 8th District Court in Lewiston, in which student lawyers go to the court every Friday to represent plaintiffs seeking protection from abuse orders. These are highly charged, emotional, difficult cases. Most plaintiffs cannot afford lawyers. The abuse statutes are not easy for lay people to grasp. Emotions run high, and the court greatly appreciates the presence of competent lawyers at these cases. For over 20 years, the program she created at the 8th District Court has been highly valued by the judges, the abuse agencies, and the public. Second, when she was acting director of the clinic, she received a grant to build a much-needed addition to the clinic building. And she navigated the design, the permitting, and the construction through all the red tape and bureaucracy of the university, of the city of Portland, and of the law school, all while keeping the clinic functioning and getting the job done on time. That's no easy task. Third, she was a primary player in coming up with the idea, in securing the funding, in getting everyone on board, and actually getting up and running a program that, as far as I know, is unique in the United States. That's the Prisoner Assistance Clinic at the law school. In that clinic, each week, student lawyers go into the main correctional center and the women's center to help inmates with civil cases. Imagine for a moment the initial reaction of the Department of Corrections when they were asked if they would let law students have full unfettered access to all of their inmates. Yet she got the cooperation of the DOC. She got the funding with the help of Kaylee and Lewis and the Maine Bar Foundation. She brought the law school and the university on board with the DOC. And since 2003, the Prisoner Assistance Clinic has been a valued and integral partner with the Department of Corrections. The legal problems of inmates don't go away while they are incarcerated. And being able to take care of child, family, probate, and all the many civil issues of life while they are inside helps the individuals as well as the administration in many uncounted ways. One of the roles of the Chief Justice is to lead the judicial department. There was some discussion earlier about, do you follow the law? Do you do justice? They are sort of the same thing. They are closely related. As lawyers and in law school, we learn that it is not enough that justice is done. Justice has to be seen to be done by the public to have the credibility and the faith in the judicial department. Justice Stanfill understands that, knows how to do it, knows how to lead the department of the judicial department through the next set of challenges. I urge the approval of Valerie Stanfill's nomination to Supreme Court Justice and to be Chief Justice of the Maine Supreme Judicial Court. And I would be happy to answer any questions any of you may have. Thank you.
Thank you very much. Committee members, are there any questions for Jim Burke? I am not seeing any. We appreciate you providing a statement today.
Thank you.
Next, we'll hear from Justin Andrus. Welcome, Justin Andrus, to the Judiciary Committee. You can proceed with your statement.
Thank you. Good morning, Senator Carney, Representative Harnett, members of the committee. I know most of you know me, but I am Justin Andrus. I am testifying today in my individual capacity as a resident of the city of Bath. I am not here representing the Maine Commission on Indigent Legal Services, although it's a longtime provider of defense services to indigent people. I have no doubt that Justice Stanfill, as Chief Justice of the Maine Supreme Court, would be a boon to those individuals. I'm an attorney licensed to practice law in Maine since October of 2002. Before that, I spent a year in the Cumberland Legal Aid Clinic, where I had the benefit of Professor Stanfill as my first educator and first supervisor of legal services, followed then immediately by Professor Burke, who you've just heard from. Earlier, Judge Dobson said to you that she called her Judge Stanfill was the gold standard for judging herself in terms of her performance as a judge. And I just want to reiterate that. After 20 years, it's 20 years this week since I appeared at the clinic to start my first day. What I do in the practice of law is driven at almost every stage by what would Professor Stanfill have thought about this, or what would she think about what I'm going to do. Others have talked to you about Professor Stanfill's intellect and abilities as a judge, and so they're all correct. She's an eminently qualified candidate, but I will, for the moment, leave that to the side, because I think it might be helpful to hear what it's like to be a lawyer in Justice Stanfill's world and what she means to the bar in terms of what she will promote if she's the Chief Justice. I was a reluctant student when Professor Stanfill met me. I actually talked with her about giving up my seat at the clinic because I was disenchanted with the erudition of legal argument. And Professor Stanfill asked me to come and work and told me that when I met the clients, and understood what it was that a lawyer does, I would begin to understand, and I would see why this is so important. And I was looking forward to telling you about how Justice Stanfill evolved from a professor into a judge who sees the people first, but everyone's told you that because it's absolutely correct. She taught us that as lawyers, our jobs were to represent the community through the individuals that we worked with. Our jobs were to partner with the courts to educate the judges, not just about the law, although certainly about the law when it was important, but to tell the stories of the clients and make sure that the individuals who would not otherwise have had a voice be able to appear before the court and be heard as people, as members of the community. Because at the end of the day, although the law is complicated, it is not designed for erudition. It is designed to serve the people. And starting as Professor Stanfill, that was always the case. That was always the message for the years that she was at the clinic. Those of us who had that experience learned. And I apologize for the rooster in the background. If I can hear it, you can probably hear it. Perils of work from home. So Professor Stanfill became Judge Stanfill. And I tripped over myself at her first confirmation hearing too, called her Valerie in the proceeding, embarrassed myself a little bit, but was delighted when she became a judge because she brought the same things. In her courtroom, she became the partner. She became the judge who was willing to be educated. You did not come unprepared. You did not come with a meritless argument, but you came with a story about your person or your people, and you told this interface. And government worked to serve the people. The decisions were appropriate. Some of them were brilliant. Some of them were brave. They're all the things you've heard about. And I won't reiterate all of that, except to say that standing in her courtroom, you always knew that you were representing the community, represented by the person you were standing next to representing. Today, we're at a place where our communities, our government is as fractious as I've ever known it, and where it is vitally important that the judicial system, which is the place where most citizens actually intersect with government, be centered around the individuals who represent the communities it serves, and that the lawyers who practice in that community and in those courts be expected to partner with the court, to partner with each other. You heard from, forgive me, I forget, it may have been Mr. Hobson about then Attorney Stanfill having relationships with opposing parties and all of that to continue to serve the public good. I have no doubt and absolute confidence that Justice Stanfill as Chief Justice means the courts will continue to recognize and serve those individuals, to recognize and serve the community. On behalf of myself, my family, and bar, I very much hope that you will recommend her confirmation. Thank you for hearing me.
Thank you very much. Committee members, are there any questions for Justin Andrus? I am not seeing any. Thank you for being here today. And next we'll be joined by Laurie Boxer-Macumber.
Good afternoon, Senator Carney and Representative Harnett and members of the Judiciary Committee. My name is Lori Boxer-Macumber, and I am here today in Portland, Maine, testifying on behalf of the Maine Child Lawyers Association. You have heard an incredible amount about Justice Stanfill's background, so I'm not going to repeat that. What I'm going to add to what you've already heard today is information from our Maine Child Lawyers survey on Justice Stanfill, because I think that will help also inform your decision making. So as you know from other testimony that I've offered to this committee, when we survey our membership, we ask them to speak to a nominee's experience, temperament, skill, and ethics. And then our Board of Governors adds to those results their own experiences with the nominee and the process. In this particular case, the candidate received very high evaluations. with respect to her previous service on the district court and the Superior Court, members of our board noted that she had previously scored high as well. Survey participants called her among the best judges that they have encountered, and they've noted that she treats all litigants with respect and courtesy. We also had someone say that it's a pleasure to practice before her, and that her decisions are thorough, but also timely, which is very important. They lauded her intellectual depth in presentations on the main rules of civil procedure and evidence. And we also heard that she was smart, hardworking, highly ethical, and kind, which we've heard is a very important quality both to her and to many of us. Some have predicted that the nominee will become an excellent Chief Justice, and our board concurs with that conclusion as well. Another thing that I can add to the testimony that's already been given is the fact that Judge Stanfill has also participated in our College of Trial Advocacy sessions. And one of the things that we've learned is that both newer and seasoned attorneys attending the college deeply appreciated the feedback that she gave. And there was a strong commitment shown on her part to making attorneys better attorneys rather than just offering constructive criticism. She had a deep belief that people had the capacity within them to become better attorneys, and she was invested not just in giving them feedback, but in helping them to become better attorneys over time. I understand that at some point, Justice Stanfill made some type of remark along the lines of the most important thing that judges do is not just to listen, but also ensure that people are confident they've been heard. And that's something similar to what we heard Professor Burke saying earlier, that, you know, even though a lot of us often know that justice is being delivered, it's important for people to see and understand that justice is being delivered, and it's critical that our judges convey that to the public, and that's something that we see Justice Stanfill as having as well. So our association is very proud to endorse the candidate before you, and I am happy to answer any questions that you may have on behalf of the Maine Trial Lawyers Association.
Thank you very much. Committee members, are there any questions? Not seeing any. We appreciate you being here today.
Thank you.
And next we'll hear from Andrew Robinson.
Good afternoon. Can everybody hear me okay?
We can hear and see you. Welcome to the committee, and you may proceed.
Thank you. Senator Carney, Representative Harnett, honorable members of the Judiciary Committee. My name is Andrew Robinson, and I am the District Attorney for District 3, which includes Androscoggin, Oxford, and Franklin counties. Thank you for allowing me to be here today to testify in support of the nomination of Justice Valerie Stanfill as Chief Justice of the Maine Supreme Judicial Court. I know you all have been very busy these last few months and have had to make difficult decisions about our laws and the future of our state. Today, Governor Mills has made your work easier by nominating an intelligent, hardworking, experienced, and most importantly, fair jurist for your consideration. I believe these qualities and her strong administrative skills make Justice Stanfill the perfect choice for Chief Justice. My experience with Justice Stanfill stems from two periods during our respective legal careers. I first worked with then Judge Stanfill in Franklin County towards the end of the 2000s as an assistant district attorney. Judge Stanfill regularly sat as the district court judge in Farmington. I quickly came to respect Judge Stanfill's grasp of the law and how fair she could be when making decisions. That is not to say that she always agreed with every argument I made, but I always knew that her decisions were based upon the law and resulted in a fair decision. Eventually, Judge Stanfill began sitting in Kennebec County, and I continued to prosecute in Region 3, so our paths diverged. However, our time together left me with a great deal of respect for her, which was shared by many of my colleagues. Our next shared work experience came after I was elected district attorney and Justice Stanfield became the sitting justice for Androscoggin County and the scheduling justice for Region 3, which includes Oxford and Franklin counties. Justice Stansfield's presence in the courtroom was what I remembered from our Franklin County days, always prepared, aware of the pertinent law, straightforward in her assessment of cases, and fair in her final decisions. I believe this assessment was shared by all members of the bar, including prosecutors and defense attorneys. Our local court system was running smoothly. Then March of 2020 came, and everything turned upside down. Justice Stanfield began taking measures to address the pandemic and its impact on our courts, and I began to appreciate her amazing administrative skills. How do you keep a criminal justice system functioning when you cannot bring groups of people together, especially when you have to meet the due process requirements of the Constitution? Many people across the state worked hard to answer this question, but in our region, it was Justice Stanfield who led our coordinated efforts to keep the criminal justice system functioning. To give you just a couple of examples, Justice Stanfield coordinated efforts to appoint attorneys for all people charged with crimes prior to their arraignment to try to limit the amount of time each person would need to spend in court and have the guidance of an attorney. Justice Stanfield also coordinated moving our region to remote hearings whenever possible. The results were a safer court system that ensured everyone's rights were being honored. I could take up the entire afternoon talking about the mechanics of making these changes and how decisions were made, but it is safe to say that it took a lot of people working together to make them happen, and Justice Stanfield was the one in our region who was leading us through these changes. From my perspective, a crisis came and Justice Stanfield rose to the challenge and showed an incredible amount of leadership to address something that our court system has never seen before. Justice Stanfield's role in our response to the pandemic increased my respect for her as a judge, especially as an administrator for our region. Before I end, I'd like to share with you one example of who Justice Stanfield is as a judge. While in Franklin County, Justice Stanfield worked with the juvenile docket as part of her assigned responsibilities. During that time, she identified that substance abuse was having a major impact on the lives of many of the juveniles coming into her courtroom. In response, Judge Stanfield asked the clerks to schedule the cases with identified substance abuse issues for a separate docket time. The result was sort of an ad hoc juvenile drug court, and she assigned herself to oversee it. This is remarkable given the limited amount of time a judge has to accomplish all the work they are responsible for when not sitting on the bench. It took away from her administrative time, but she did it because she cared about the juveniles coming before her, and she thought this would be a better way to handle their cases. This decision by then Judge Stanfield told me a lot about who she is as a judge, and more importantly, who she is as a person. Thank you for giving me the opportunity to share my thoughts and experiences with you regarding Justice Stanfield. I hope they help you make an informed decision. I'll tell you, I spent a little bit of time reading nomination speeches by presidents for Supreme Court justice nominations, and I thought to myself, well, you would be better served by having my personal experiences, because I knew Mr. Hobson and Mr. Reed were going to do a wonderful job, as they did, admirably describing her as a complete judge. But I will tell you this, that I encourage you to support the governor's nomination of Justice Stanfield to Chief Judge of the Maine Supreme Judicial Court. Her intelligence, work ethic, experience, and inherent sense of justice all support this decision. Thank you, and I'm happy to answer any questions you might have.
Thank you, Andrew Robinson. Committee members, are there any questions? I am not seeing any. Thank you so much. Next, we'll hear from Kelly McDonald.
Hello, and can you hear me?
We can hear you just fine.
It is the traditional beginning to every speech that you've heard today. Good morning. Senator Carney, Representative Harnett, and members of the Joint Standing Committee on the Judiciary. My name is Kelly McDonald. I am a citizen of Portland. I am here today on behalf of the Maine State Bar Association to share with you, to speak in support of the nomination of Justice Stanfill that is before you today. As you know, the Maine State Bar Association regularly polls its members to determine how our judges are doing. And I have appeared before you on a number of occasions to share the results of those polls for various judges. And so you've heard so many great things today from the speakers that come before me. That's one of the perils of speaking later in the list is the fear of being repetitive. What I would like to share with you today, though, is not just my view, but instead the view that is shared with you by our nearly 3,000 members across the state of Maine. The last evaluation that we did of Justice Stanfill is somewhat dated, I'm afraid, due to her rapid change of positions. We evaluate judges in the second and sixth year of their judgeships. And so we conducted an evaluation of Justice Stanfill in 2013 when she was on the district court. When we were getting ready to do another 6-year evaluation of her, she up and went to the Superior Court. And when we were getting ready to do her 2-year evaluation, well, we haven't gotten to that point yet either, I'm afraid. So despite the fact that this data is from 2013, it is consistent with what this committee has heard today. Our members share that Justice Stanfill is a strong, decisive, and confident judge. They describe her as being intelligent, knowledgeable of the law and procedure, and professional in her dealings with attorneys and clients alike. The lawyers who have appeared before Justice Stanfill consider her to be fair and efficient, always well prepared, and prompt in issuing her decisions. And I can tell you as an attorney, that last piece, being prompt in issuing decisions, is particularly valuable. She has earned the respect of Maine lawyers for her high standards of work and conduct and her excellent courtroom management. In addition, Justice Stanfill is a longtime member and supporter of the Maine State Bar Association. As you heard from her, she served as co-chair of the Women's Law Section in 2005 and 2006 and has been gracious enough to serve as faculty on numerous CLE programs throughout the years. Her connection to the MSB demonstrates her support of the legal community, access to justice, and the rule of law in Maine. For all of those reasons, I am delighted to report to you that the MSBA strongly supports the nomination that is before you for Justice Stanfill on behalf of all of our members. I would be happy to answer any questions the committee might have of me. Thank you.
Thank you very much. Committee members, are there any questions for Kelly McDonald? I am not seeing any. We appreciate you providing a statement today.
Thank you very much.
That concludes those who wish to speak in favor of the nomination. Is there anyone in the attendee portion of the meeting who wishes to speak in opposition to the nomination? If so, please raise your hand. I am not seeing anyone. Is there anyone remaining in the attendee portion of the meeting who wishes to be heard on this nomination? All public comments having been taken, the committee will now proceed as follows. We will review any additional written comments on the nomination that have been received by the committee, and we'll check with our committee clerk and ask if any additional written comments have been received.
There have been none, Madam Chair.
Thank you very much. And now we will proceed to a vote on the nomination and to notify the President of the Senate pursuant to Title III, MRSA Section 157, and the joint rules. The vote must be taken within 40 days from the date of the governor's written notice, and we are within that time frame. The hearing of the Joint Standing Committee on the Judiciary for the nomination of the Honorable Valerie Stanfill of Wayne for appointment as the Chief Justice, Supreme Judicial Court, and Justice of the Law Court is now closed. We'll move on to taking of the vote. In accordance with the law, the committee may not take a vote on this nomination sooner than 15 minutes after the close of the public hearing, unless all members of the committee who are present agree. At this time, therefore, I will inquire as to whether any member present objects to proceeding to taking the vote immediately. Does any member object? Senator Kime, would you like 15 minutes? Thank you.
Yes, I would. Thank you.
Thank you. And so at this time, it is 12:18. We will take a 15-minute break. And rather than coming back on an odd number, we will return at 12:35, everyone. So we will take a brief recess until 12:35. Thank you.
Thanks.
And committee members, please turn off your audio and video because the live streaming will continue. And we'll be back shortly, everyone. Committee members, it's 12:35. If you are at your desks or computers, if you could please activate your video so that we can resume when everyone returns. Thank you. And I see that we've just got a few more committee members to join us. I think Representative Harnett, Co-Chair Harnett, will be joining in just a moment as well. So let's give him a minute to get back from the break. Wait, give me just a moment, please, to check in with him. I'll be right back. All right, it looks like we are back, and as we proceed to the vote, committee members, please keep your audio and video on. Thank you very much. So the pending question before the committee is that the Joint Standing Committee on the Judiciary recommend to the Senate of the 130th Maine Legislature that the nomination of the Honorable Valerie Stanfill of Wayne for appointment as Chief Justice, Supreme Judicial Court, and Justice of the Law Court be confirmed. In accordance with 3 MRSA Chapter 6, Section 157, and with the joint rules of the 130th Legislature, the vote will be taken by the yeas and nays. A vote of yes will be in favor of recommending the confirmation. A vote of no will be against the motion to recommend confirmation. Is the committee ready for the question? It appears that we are. The committee clerk will call the roll.
It will be my honor and pleasure, Madam Chair. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone.
Yes.
Representative Cardone votes yes. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Hagan. Representative Hagan is absent. Representative Newell. Representative Newell is absent. Madam Chair, 12 members voted in the affirmative, 0 in the negative, and 2 members were absent.
Thank you very much, Ms. Panett. 12 members of the committee having voted in the affirmative and 0 in the negative, it is the vote of the Joint Standing Committee on the Judiciary that the nomination of the Honorable Valerie Stanfill of Wayne for appointment as Chief Justice, Supreme Judicial Court, and Justice of the Law Court be confirmed. Justice Stanfill, thank you very much and congratulations. This is
Thank
our
you.
new tradition. We would otherwise be coming out from behind the horseshoe to take your hand.
And thank you to everybody on the committee for your hard work all year, frankly. So it's appreciated. Thank you very much.
We appreciate all your hard work this past year and look forward to your service as Chief Justice.
Thank you.
And with that, we have completed our work on the confirmation hearing today. Committee members, we do have a significant number of language reviews to do this afternoon, but I think it makes sense to take a brief lunch break before we dive into all of those language reviews. It's 20 of 1 at this point. Committee members, is everybody comfortable returning at 1:15? Representative Moriarty, go ahead.
Madam Chair, are we doing any of the tabled bills today?
We are going to hear back from some report backs from legislators who were going to try to work out resolutions on issues, but I'm not sure if we'll take up tabled bills yet. We won't know that until we actually take up our work at 1:15.
I see. Okay.
All right, is that acceptable to everybody? 1:15? Peggy and Soupy, does that work for you as well? Okay. All right, everyone, we will be in recess until 1:15. And thank you once again, Justice Stanfill and John Hobson and Jerry Reed.
Thanks then.
Hi, committee members. If you have returned, please activate your camera so we know who's here and ready to get diving into our language reviews. We'll get started in just a moment. All right, committee members, thanks for all of your great questions during the nomination hearing or the confirmation hearing this morning. And I think we're ready to dive into language reviews. Peggy, do you just want me just to turn it over to you?
Sure. Well, I can keep you going all afternoon.
Yeah, I think you've got a stack of virtual paper for us.
Right. And I'm sorry I filled up your inboxes. And I'm not really sure the best way to do it, but I guess what I would like to focus on are the ones that really need your attention, such as something that has a mandate and we haven't really talked about it. And I'm sorry I don't have a list, and I'm trying to turn it into a photograph into something I can email, and that didn't work. So the list I sent last night, I don't know if that's useful. How about if I just tell you the LD numbers that
actually
I would like you to look at first?
I did a screenshot of all of the documents after I pasted them into a folder on my computer. Do you want me to send that screenshot to you? Or send it to the whole committee?
Well, I mean, I have a list I can work from. I just don't know if that's helpful to the whole committee.
Okay. All right.
So how about I tell you the ones I like to focus on, and then we can move on after that. So I'm going to give you a list. 480, 560, 679, and I will be able to share all these on my screen. So 853, 879, 1236, 1294, 1303, and 1345.
Peggy, are all those in the group that you sent last night? Or some are from earlier?
I think 480 is from earlier, and you actually reviewed 480 before. 480 is an act to establish a presumption of entitlement to counsel for a person who's a subject of an adult guardianship, conservatorship, or other protective arrangement proceeding. There is and so you already had that. I did not resend that. I'll be happy to resend it if you want, and I can share it on my screen.
I think screen sharing would be really helpful.
Yeah.
Peggy, thank you.
I apologize. I was on the phone and missed the 3 after 480.
The 3, there were more than 3.
Oh, okay. Then I really missed. Well, no, I have others. I have others, but I just seem to miss between 480 and 853.
Oh, okay. I'm sorry. My screen is not sharing.
Oops. That's okay. I don't want to delay. If I have to pull anything fast.
560 and 679, Soupy.
679. Thank you very much.
560 was immediately after, and then 679.
Okay, perfect. Thank you.
There we go. Now I can do it.
Screen share.
Okay, I got it.
Okay.
I had to close a bunch of other windows. Okay. So this is 480. You actually already looked at this and approved it and said, okay, yes, we know it's going to cost money to Health and Human Services Department in this situation. It is a divided report. It's a majority ought to pass as amended report. But what we didn't talk about is later on, because this is dealing with probate courts, it's identified as a state mandate. So that means that those costs that Health and Human Services Department are looking at, there might be some costs to the probate courts, which means the counties, to appoint attorneys in situations where they are not currently being appointed. So I'm not sure if we've really talked about mandates that much in the past, but you have some options when something is identified as a state mandate. One, it's the role of the Office of Fiscal and Program Review to determine if proposed legislation is a mandate or looks like it might be a mandate. And the mandate is defined in the state statutes. And it's recognized in the Constitution. So once it's identified, you need to figure out if you agree whether it's a state mandate. And then what do you want to do with it if you think it might be a mandate? And although I think this fiscal note is incorrect because it says unit affected as municipality, that really should be counties. You can decide to fund 90% of it by creating a fund in the Department of Administrative and Financial Services and figure out what that cost would be and fund 90% of the statewide cost. Or you can add a mandate preamble, which takes a 2/3 vote, and it says, this is such an important thing that we're going to make whichever local government entity absorb these costs, or maybe we don't think the costs are that significant and we want them to be able to absorb those costs. And so that's what the 2/3 is, that the state's not going to pay it. The last thing you can do is just leave it, which then kind of leaves things up in the air. And if the local government unit decides that complying with the law would expand what they do and would cost more, then they can refuse to do it. And that they have that right underneath the pursuant to the Constitution and the law that governs mandates. So I realized that you had looked at this bill, you thought you were done, but we really have to deal with the mandate issue somehow.
Peggy, is this one where the registrars of probate said that they felt like their current practices would have the same outcome as the amended statutory language?
Well, in the past, I think the probate judges, I'm not sure it's the registers, because it's the judges that have to appoint the attorneys. They have testified in the past on similar bills. I'm not sure if they said that on this one, which is the same, that they believe an attorney has been appointed in every case where an attorney is needed to be appointed in these cases, because right now the law requires them to appoint an attorney if the adult who's subject to this proceeding has any questions, wants to limit the guardian's powers, is concerned about it, and the judges have been very forthcoming about saying we recognize those concerns and we appoint attorneys in those cases. Not that it's always easy to find an attorney, and that's what the registers will tell you, is because they're the ones who have to find the attorneys very often. So I don't know if that answered your question. They I think the probate courts would have I think they have told you in the past they don't feel like anybody who needs an attorney is not getting one now. There are people who testified in favor of this bill who felt there were situations where an attorney should have been appointed.
Thank you. All right, and Peggy, do we know what the estimated costs are to the counties? I didn't look at this.
Right. Well, and actually, I'll bring it up now. And if you want to think about it, and I can try to get some more information if you need more information, and we can try to finalize how you want to go forward with it on Friday if you want. But I need to at least raise this issue so you're thinking about the mandate. I don't know how many public guardianships there are and that's why DHHS has put on their fiscal note their appropriation. And I don't know how that compares at the county level. And I'm not sure. I mean, they've identified a significant cost statewide, yet if most cases that need attorneys are already being appointed, I'm not sure how you estimate what that difference is between who's being appointed now. So those legal costs that are incurred now and what would be incurred under the bill.
Right.
Yeah, so I don't know how you estimate 90% of that either to put it into a fund. If you say this is really important, we want to fund it.
Mm-hmm. Okay. Representative Harnett?
Thank you. Peggy, we may have done this before, but can you explain to me in 30 seconds the significance of the change from clear and convincing to preponderance?
So
does this make it more likely or less likely that these are going?
It's less likely that attorneys will be appointed by changing that standard, because the default is appoint an attorney unless the court finds by clear and convincing evidence then that an attorney is not needed, and it's been changed to a preponderance. So it's by changing that standard, it's less likely that the court will be appointing an attorney, because it'll be easier. It'll be easier to show that an attorney is not needed.
But in the original bill, though, it was clear and convincing.
It was. Yes, it was. And it starts out as the default is an attorney gets appointed.
Unless there's a preponderance of the evidence showing that one is not needed.
Right, or that the person's already represented, obviously, or that they've knowingly waived their right to an attorney.
Okay, so a much lower standard. Thank you.
Peggy, can you just please end screen sharing for a minute so we can see?
Oh, yes, I'm sorry.
Questions? No, that was super helpful. Committee members, does anybody have questions or a suggestion about how to proceed? All right, so I think that maybe I can come up with a recommendation for the committee for Friday, if that is helpful to everyone. And if, as you ponder it, and you have recommendations or suggestions, email either Tom or I. Does that seem like a good way for everybody to proceed?
Sure.
Okay. Thank you for bringing that up, Peggy.
So the next one, this is really pointing out to you, and you need to approve the appropriation LD 560, which is the safe haven baby, what do they call them? Baby
boxes. Baby box.
Boxes.
Baby boxes.
Yeah. Oh goodness. Why? There it is. So this is unanimous report. Man alive, I'm not getting good at sharing today. It's a unanimous report, and the fiscal note, it actually, because we're directing the department to adopt rules, there's a fiscal note of $63,000 on it. Not just a fiscal note, an appropriation. I'm sorry, I'm trying to get my screen. Well, we'll just share it this way. How's that? Okay, can you see that?
Yep.
Okay, so this was a unanimous report, and you dealt with where the devices would be, and that the department would adopt rules to ensure that they were safely designed, installed. They had that connection with 911 or a public safety answering point. And then, surprise, the one-time funding to contract for technical support, developing rules to implement the program. It's not ongoing cost, but it's a one-time cost. So I mean, this is a significant change, I think, from the bill that wasn't anticipated, but it's understandable at the same time.
Senator Kime?
Thank you, Peggy.
I'm gonna stop sharing.
I find it interesting that the department is charging so much for rulemaking. I think a lot of times we get rulemaking without a fiscal note.
Well,
So,
I think it, right, I'm sorry.
no, I'm just wondering if you can put that in context for me with other things. And I understand technical support, but other states have done this, so it doesn't seem like they need to reinvent the wheel.
Right, I don't know. I mean, it's not just rulemaking, it's working with somebody who understands what the specifications should be in order to install one of these devices and make sure that it's safe for the baby and will trigger the response by whoever is supposed to be monitoring it. I wouldn't be able to hazard a guess about whether that's a reasonable amount.
Or what about other bills that we have asked for rulemaking to happen? That part surprises me. Do we have any comparison between other times that rulemaking has been so expensive?
I guess usually when I think of rulemaking, it's not as physically, the specifications aren't as physical, they're more legal. And so they usually absorb those costs. These, not only do they have to adopt the rules, but they have to figure out what makes sense from a safety perspective. And I don't know if that's true with, like, when the State Fire Marshal's office has to adopt rules with regard to safety inspections. And I don't know. I don't have experience with rules having that significant cost.
Mm-hmm. Okay, thank you.
Representative Harnett, I think you're next.
Actually, Senator Kime asked my question. It just seemed like a high dollar number for rulemaking, but so I don't have an additional question. Sorry.
Okay. Yeah, and I think what we're hearing is that there has to be some kind of acquisition of technology. And we did have another bill that pertained to purchasing technology, but I'm not remembering what it is right now. Representative Moriarty, I think you were next.
Thank you, Madam Chair. My question may be a little naive. In issues like this, Peggy, involving rulemaking, is this not done in-house by salaried personnel, or is it truly a new and additional expense from contracting or whatever?
Well, I don't know. I don't know the expertise of anybody in the Department of Health and Human Services that would really have knowledge about these things.
I see.
It's not like a lab test or, some of the things we normally think about the Department of Health and Human Services overseeing.
But did the person who did this analysis send you a message saying we're going to have to contract this out or hire people? Or
you have the information I have, which is to contract for technical support, developing rules to implement the program. So if you remember, some of the testimony said it's really important to make sure that there are requirements, there are specifications. So you don't have some well-meaning person who doesn't take everything into account, say, oh, I'll install one of those for you. And when in fact it ends up being dangerous. So I think the people who are in favor of installing these are in favor of specifications. I'm just not sure if they recognize that the department would identify these costs.
Okay.
Representative Rackett and then Representative McCray.
I have to say I'm losing my enthusiasm rapidly for this bill. And it seems to me if it's an outside group who has been advocating for this all over the country, then ought they not have funds to help with the implementation? And if not, I'm not sure that there's a huge difference going on whether we do this or don't do this. And so as I say, I'm rapidly losing my enthusiasm because I can think of a lot of things I'd rather spend $70,000 on than telling people how indeed to install boxes that frankly is a function that's being done now, I think, by ERs or occasionally a fire department here or there. I mean, I don't know, it sounds crass, but it just seems like a hell of a lot of money to devote to this at the initiative of whoever it is that's pushing for this nationally. So I would want them to step up to the table with some cash if they want this implemented in Maine, which sounds terrible, but so don't quote me. But I don't understand. I mean, I understand why they would have identified this as the cost. I mean, tech stuff costs a lot of money to have done, but why it has to be tech stuff, I'm just not convinced.
Representative McCray.
Thank you, Madam Chair. I think Representative Brackett's point was very creative. I was just going to say that some of the best advice I got my first session was you can question fiscal notes. So if someone wants to go to the department and or the fiscal office, it can make a difference. I did it last week. So somebody could certainly do that, question it and see what happens.
Yeah, and I think that that's a really good point, Representative McCray. I also think we have to remember that these are boxes that are going to be available 24/7 to receive newborns. And so, you know, I think that the rulemaking and technology is especially important. And so maybe it is justified or maybe it could be challenged and revised. So Peggy, are we supposed to vote to incorporate the fiscal note at this point?
Well, I think that if you're happy with the fiscal note, you've already voted to amend the bill. And if the fiscal note goes, it's an appropriation goes along with the bill, and you're happy with that, you can just kind of sign off on that. Mm-hmm. If you want to question, if you want more information, then obviously we can hold off and see what we can change.
Okay, I just want to take a quick peek and see who the bill sponsor was because I'm not remembering that off the top of my head.
I don't know why Patrick Corey seems familiar to this bill.
Hold on a second and I can tell you.
It was Corey.
Okay, so would someone like to reach out to Representative Corey and see if he is interested in working on the fiscal note? Did I see you nodding, Senator Khan? Would you be willing to do that?
Yes, I'll reach out and ask if he wants to ask the question and see what the answers are behind that.
Wonderful, thank you so much. So we'll put that on our to-do list for Friday then. Thanks.
Great, thank you. You ready for the next one? LD 679. This is an act to establish statewide electronic warrant system. This is the e-warrants. It was a unanimous ought to pass report. And now we have the fiscal note and appropriation. And come on. Here is the fiscal note and an appropriation of a lot of money from the general fund for the courts. So this is ongoing funding. The first one is ongoing funding. The second one is one-time funding, and then ongoing funding. And I think that's it. Yeah. So
is one of those for the technology underlying the,
yes. And those are, that says it's ongoing. The 82,650 provides ongoing funding for technology costs to ensure justices of the peace can access the e-warrant system. So maybe that's the one you were thinking about, Senator Carney, that you had seen other technology costs.
Yeah, I think it is. It's because there's a module that could be added on to the software that the court system's currently using, right?
Right.
Okay.
Right. And then the second one, the 78,000, that's a one-time. That's I'm assuming that's to give the justices of the peace that hardware that they need so they can link into the system. And then the last piece is I'm assuming that's in the courts themselves, ongoing funding to contract for an e-warrant system. And contracting, I believe you're right, Senator Carney, is with Tyler Technologies.
Okay, thank you. Senator Keim and then Representative Reckitt.
Thank you. So Peggy, the fiscal note kills this bill every year. So, but the part that I didn't know if you could help us remember is what was different this time is that the courts are already moving forward with an electronic system, right? Record system. And so this time when the bill was proposed, it was expected with good reason, I believe, that it would be less expensive than it had been in the past, because now it would only be in addition to what was already moving forward. So, but I don't have a comparison of an old fiscal note, so I didn't know if you did or could share that information with us. And the other thing is that we had asked if there was a way to balance the cost savings, I believe, with this, and it was hard to figure, but there is a significant cost savings. Did we get anything on that?
Not that I know of. I have a memo from the judicial branch about this that I'm happy to share. But so they identified upfront costs which match the fiscal note, and so that's kind of what that's what the fiscal office based. It's a very detailed report from the judicial branch, and I'm sorry I haven't shared it, I guess, with everybody, and I'm certainly happy to do that. I mean, we can recognize that there will be cost savings, but I don't know how you quantify them. And I think the savings are going to be more
on the county level, right?
Right, yeah, it says the Maine Chiefs of Police Association and Maine Sheriff's Association was asked to provide estimates for cost savings that may be realized as a result of implementing an e-warrant system, reduced overtime, travel, and administrative costs. Unfortunately, these groups were not able to provide those figures in time for this memo.
No.
Major Brian Scott did note it's so difficult to determine what our savings might be, but I would expect that the savings in the grand scheme of things would not be significant. That's the state police. The state police have a broader scope across the state.
Okay. And then obviously not at the moment, but could you get for me the fiscal note of what this had in the past? Because am I wrong in my recollection that because the court was already moving forward, you know, I mean, when this was first introduced, there wasn't an electronic system in the court at all. It was still just being discussed. And
Right.
so then this was huge at the time. So now I had assumed it could be incorporated less expensively.
Right, and I really don't remember what that original cost was, if they even actually had a cost, but I'll go back and look in the old files.
Okay, and then yeah, just if you could just get me the information at another time, that would be helpful. Thank you.
Representative Reckitt?
I sort of have an odd question because I'm not aware of who these days are justices of the peace by definition, because I remember they used to be justices of the peace because I was one, but then they eliminated the post and turned us all into notaries. Now, apparently somebody's morphed back, or there's some other entity that is the justice of the peace, and I don't know who that is. So I just, I'd like to know who it is that we're rigging up with this whole operation.
Right, very soon after they did away with justices of the peace, they reinstated them, and they are appointed by district court judges, I believe.
Oh, okay. All right. So I just hated to sit here and feel dumb about that.
All right, so on this one, are we also going then to wait? Senator Kine, would you like to wait until Friday after you've had a chance to track down that additional information?
I guess so, because I would probably want to, you know, if it ends up that the cost is the same, I would definitely want the opportunity to ask the court that question.
Okay, all right, we can hold on that one till we'll vote on it on Friday. Thanks.
Sorry,
Oh,
I'm still sharing.
that's good.
So the next one I have, I'm sorry, this is all bad news. LD 853 is an act to increase the fees paid to sheriffs and their deputies for service of civil process documents. I'm assuming this actually won't be a surprise to you, because you did hear from some agencies that said this will be a big cost to us. So this was a unanimous report. It's increasing the fees that would be paid. And I'm going to show you. So this is the fiscal note for, these are just state costs that would be paid because of the increase in the fees that sheriffs would. So that's the fiscal note, and here's the appropriation to match that. So there are some federal funds that they expect to be able to use. I mean, if there are federal funds, they could spend this much of them. And then there's also some costs in the judicial branch. So there's judicial branch costs and health and human services costs. That's mostly the child support, and there might be some child protection things. And then there's also funding, I guess that's it. I guess anything that anybody asks to be paid to the counties comes through those two departments. So I'm going back to the fiscal note because that just gives you a total. So.
And we were expecting that there would be a fiscal note that was fairly significant. Representative Reckitt?
What happens if the state just says we're not going to pay this? I mean, who serves the? I mean, whose ultimate responsibility is the service of civil process documents? I mean, are we currently forcing the sheriffs to do this at a loss? Or, I mean, that's what's puzzling me here.
For child support and anything where the state is a party and is asking the sheriff to serve process, then the state is paying. And in a couple of places, the state cost is like kept artificially low. It's like $1. And so this is trying to recognize their actual costs. So if the state, so if you're saying if you didn't appropriate it, everybody else who uses a sheriff to serve process would have to pay those fees. And then I don't know if the sheriffs would still be required to serve process for the state if the state isn't paying their fees.
Yeah, it just doesn't seem logical to me that the state would have the capacity to say to the sheriff, I mean, talk about unfunded mandates. I mean, you're going to have to do this, and we're not paying you, you know, or we're certainly paying you way less than it's costing you to do it. Doesn't even make sense. I mean, I think frankly we should put this forward to appropriations as it is, and let them tough it out, because the issue is, for me, is if we agree, or if the state agrees that we have to have these things served, and the sheriffs are the most logical people to do it, then why would you not pay them at bare minimum what it costs them to do it? It doesn't even make sense to me. So, but maybe Tom could make sense for me.
Go ahead, Representative Harnett.
I don't know if I'm going to make sense of it. I agree with Lois 100%. I mean, this was unanimous to pass because we felt that the counties were picking up more of the cost than they were being reimbursed for, and that was being passed on to property taxpayers. I don't know any way around it other than forcing the state to pay the higher rate. And this isn't a surprise. Maybe the numbers are a bit of a surprise, but we're asking the state, which generates about 90% of this activity, to pay its fair share. It's going to cost money.
Yeah, from my perspective, this is kind of what the intended effect was that the cost was going to be shifted to the state instead of the counties. Senator Klein?
I make a motion that we vote ought to pass as amended.
Is there a second?
Wait, can you back up just a second? So you voted ought to pass. So if you're going to add the appropriation section, then I think you need to reconsider. So I think that's what Senator Kime was saying.
I'm certain of it. I heard it right out of her lips.
Of course, Peggy.
Would you like to restate your motion?
Yes, having voted on the prevailing side, I make a motion that we consider LD, what is this number?
853.
853.
Second.
All right, there's a motion to reconsider and a second. And rather than doing a roll call vote on this, let's use our actual hands, because people who are watching on live streaming can't see the electronic hands. So those in favor of reconsideration, please use your actual hands. Representative McCray?
Can I just ask a question? Since I wasn't here at that time, am I voting or not?
I think you can
eligible to.
once we reconsider, you can vote.
Okay, thank you.
Right. but I think she's part of the committee and she can vote to reconsider, right?
Oh,
Yes.
great. Okay.
Yeah.
Thank you. Okay, so all those in favor of reconsideration?
I see 10.
2.
10 in favor and 0 opposed?
Whoa, 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 I didn't get 10. Sorry. 1, 2, 3, 4, 5, 6, 7, 9, 10. I do. Sorry, we're all jumbled, so my eyes are old.
Right. It's hard.
It is. All right, so the motion to reconsider carries 10-0. And then Senator Klein, did you want to make another motion?
Yes, I would make a motion ought to pass as amended, including the fiscal note.
And is
And
there
appropriation, yeah.
Seconded by Representative Barnett? And then on this one, we'll do a roll call vote, I think would be appropriate.
Oh. Thank you. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 10 members voting in the affirmative, 2 in the negative, and 4 members are absent.
Who was
Thank you very much.
Oops.
Who was negative?
Did I say, I think I said no members. in the-
Oh, no, I'm good.
My apologies.
I'm sorry.
I'll take a drink of water.
All right, so the ought to pass as amended prevails 10-0 with 4 absences. So we will close the reconsideration of 853. Thanks, everyone.
So the next one I'd like you to look at, and this is actually the minority report, LD 879, an act clarifying the acceptance of public funding by community benefit organizations. I don't have the vote on this. I know this is the minority report, but it does require an appropriation. Come on. So this is the bill that Senator Keim sponsored to take out the requirement that public benefit organizations not accept public funds in order to be, I'm making a mishmash of how this goes. It amends the Human Rights Act to ensure that religious corporations, associations, and organizations, whether or not they receive public funds, are exempt from discrimination prohibitions on the basis of employment, housing, and educational opportunity. So the bill takes out the limitation about accepting public funds. If they accept public funds, then they're subject to the Freedom of Access Act. I'm sorry, the Human Rights Act. You can see where my brain has been for years and years. So what this bill is saying is, if you go forward with that bill, the Human Rights Commission believes that they will need 2 half positions to look at the any issues arising from whether or not these entities are exempt from discrimination prohibitions. So one is a part-time attorney position and the other is a part-time investigator position. So there's a total, and I don't have the vote total on this. I know it is the minority report. I'm hoping
I have it,
you might be
Peggy.
able to pull that up.
I have it, Peggy.
Okay.
The motion was ought to pass. There were 4 in favor, 7 opposed, and 3 absences.
Right. So Supi might have, maybe the people who are absent have weighed in time. So she might have that.
Just so I'm clear, 879?
Yes.
Yes. The ought to pass 5, the ought not to pass 9.
So this is really just for the people on the minority report, is changing their report from ought to pass as amended to include that appropriation. Not sure how you go about doing this. I mean, you can vote to reconsider, or you can just agree that the vote ought to pass was, well, you really should vote to reconsider, to change the vote from ought to pass as amended. However, I'm not sure the people who are on that report would be supporting this change.
Oh, Senator Keim, this was your bill. Would you like to reconsider, to revote it?
Well, Peggy, what if I don't? What if we don't reconsider and we just leave the fiscal note out there? Does it really matter? The bill's not going to pass. The people aren't here to vote on it, and I'm not on the prevailing side. So, how do you vote reconsider a bill that
you rely on the good graces of the people on your committee?
And what if we just leave it?
I'm afraid that I'm trying to look through the joint rules to see what it says about fiscal notes and being not properly before the body if it comes out of committee without a fiscal note. I don't know if that.
Senator Keim, if you wanted to reconsider, to revote it so that you could vote ought to pass as amended, we can certainly do that. And also, Co-Chair Harnett, do you have some words of wisdom for the committee?
No, I have no words of wisdom today. I only have questions. Why would I be voting on this motion? I don't understand. It was an ought to pass that garnered 5 votes. Wouldn't it be those 5 people that would be voting on whether to change it to ought to pass as amended? I mean, I'm happy to facilitate that, but I don't. We would all vote on a motion to reconsider something that we never voted for in the first place?
Madam Chair, may I pipe in?
Okay.
My understanding would be that the minority can clarify by themselves their report, or we can reconsider if the opportunity for people to change their mind on their vote is desirable. In other words, the reconsideration would be to give the opportunity for others that didn't vote with the report in the first place to join. Other than that, I think they have the power to change their report on their own since it's already been voted.
I'm not sure that's the case, because it's changed from ought to pass as amended. So if there had been an amendment in committee, then we would not need to do all of this, right? Yeah. So it is a courtesy to our colleague who's the co-sponsor to allow her to change the ought to pass. But
I would have guessed you could poll the minority to determine if they chose to report out ought to pass as amended or to stay with their original vote. But I defer to your decision, because It works either way. Thank you.
What would you like to do, Senator Keim?
It so doesn't matter to me. I mean, if, it's going nowhere. So I'm totally fine with, leaving it or revoting it, but it doesn't make sense to me to have the committee revote a bill that they aren't in favor of. That's the only thing. I feel like we're missing something here where we would normally just be able to, as a minority, put on a fiscal note if that was necessary. But whatever is proper to do, I'm happy to do.
Okay, so let's do this. Let's leave it as is, and Senator Keim, if you have an alternative process that you would like us to follow on Friday, we can do that. If you learn that there is a way to accomplish what you want. Oh, Soupy, do you have a suggestion?
I was just going to add, and I don't mean to, it's that when I report out the bill, just so you all know, it's going to say ought to pass. If it has a fiscal note, it's going to say ought to, the report is going to say ought to pass as amended. So I'm not,
what we do right
you
now.
may know better than me, but that's what I do. So I just need to let you know that it's not going to be reported out ought to pass. If I know it's got a fiscal note, it has to go out ought to pass as amended.
Okay, then I think that settles the issue.
So I think it's really important that you do this like you're doing in a public setting, that you all are recognizing that the minority report is actually ought to pass as amended. I'm assuming that you want to do that, Senator Keim.
That is, I think that's the goal of the committee, that the minority ought to pass report reflect incorporation of the fiscal note.
Okay, you're okay with that, Soupy?
I'll just put an A. Yep.
Okay.
See everyone nodding, and so I think that we have resolved that issue.
Great.
Thank you, everyone, for your contributions.
And Senator Keim, can we quote you that this bill is going nowhere? Is that okay?
I think it's obvious.
Okay, I was just kidding.
Okay. The next one is LD 1236. And this is an act authorizing the Attorney General to enter into contingent fee agreements. The majority, I have 8 voted in favor of ought to pass. Minority of 5 and 1 absent. Minority was ought not to pass. We need to add a fiscal note to it. So in light of what you just did with 879, perhaps you want to say adding the fiscal note was part of your.
Yes.
Yes.
Is that okay with you, Soupy?
I'm fine.
When we voted on it, that if there was a fiscal note, it would be added. Thank you.
Right. So, and this is a fiscal note, not an appropriation. It just says there may be costs.
Thank you. Representative Moriarty?
I'm just not understanding how there are costs if there's a contract with a private law firm which agrees to pay all costs and accept that risk. I didn't think there were any state costs involved.
Well, somebody has to arrange for the attorney.
That's the phone call.
But it's where the money comes from for the contingent fee. And it would be, let me show you the fiscal note. So, which is not right there.
Yeah,
well, it's a matter of the state getting less than a full recovery because the private law firm takes a percentage if they're successful.
I think it's just reflecting that money would technically come into be received by the state, and then technically the contingent fee portion would then go out of the general fund. And so it doesn't indicate any amount. Right. It just says to the extent private counsel employed by the Attorney General on a contingent fee basis recovers funds, the Attorney General could then deduct and remit to private counsel any amounts due. So I think it's a very, once you untangle it, it's a very commonsensical thing. It's just saying if the state recovers in a contingent fee case, then the contingent fee is going to be paid to the counsel that did the recovery.
But it's still a net recovery to the state. So I'm just logically not.
You would think. Can I share it?
Yes.
You want me to share it? Is that helpful?
Great, thank you.
Right. So they're also identifying it as other special revenue funds, which means it's not general fund money. It would be without this law, and they received a settlement, then that would be other special revenue that's coming in. And so this says there might be a cost increase to that other special revenue fund because they would be paying contingent fees out of it. On the other hand, there might be a revenue increase because they might be getting this settlement because they hired attorneys. If that makes sense. It's really just a flag. It's not saying any particular amounts. But the situation is you voted ought to pass, and this has to be added to the bill.
Yeah. Representative Harnett, go ahead.
And I really don't want to belabor the point. This just allows the state to live up to its obligation when it agrees to the contingency fee, that the state's going to be, say, awarded $1 million, and then $333,000 is going to go, it's going to come in, and then the contingency fee is going to go out. It's just like it's a paper transaction. And the other special revenue is the award of the money or the settlement, the proceeds of the settlement. At least that's how I see it.
Yeah. Representative Babbage, did you have a question?
Yes, I wanted to ask a clarification from Peggy, if I could. There are fiscal notes with appropriations. There are fiscal notes without, but those without are special revenue or unspecified amounts, and they all go to the appropriations table. Is that right?
No, not necessarily. So it's my loose vernacular that has messed things up, because a fiscal note is really just what we looked at. It's a little narrative about potential costs or savings, and it is not a dollar figure. If you require an appropriation, like for the sheriff's fees, that's an appropriation. So that bill, we're actually adding on an appropriation section, and we're adding a fiscal note, because the fiscal note says, here's what's going on with this bill. But the appropriation actually transfers money or makes that money available to be used for those purposes. So this bill, 1236, does not require an appropriation section.
It's good that I clarified that in my 6th term. Thank you.
It's because we call everything a fiscal note. Or a physical note. Okay, so my understanding is the majority was agreeing to add that fiscal note to their report. So their report on 1236 is ought to pass as amended.
Exactly. Thank you.
Okay, the next one also is a divided report. I'm looking at LD 1294. This is an act to prevent discrimination against domestic violence victims. If you remember, it amends the Human Rights Act to include prohibited discrimination in housing against somebody who has a protection from abuse order. And you amended it to make sure it was only the final order. So rather than referencing the whole chapter 101 of the protection from abuse statutes, we cross-referenced section 4007. So the Human Rights Commission identified, where am I? That there are costs involved in that. So here's what the amendment looks like. All those cross references. Lots and lots and lots of cross references. And then we get to the costs. So the Human Rights Commission identified this as needing at least half a position of a human rights investigator due to the anticipated increase in complaints. And so that's what this is an appropriation, not just a fiscal note. So here's the appropriation. 59,000. There's some one-time costs or initial costs there in the first year. And then here's the fiscal note. So it does explain what the appropriation section is doing, but then it also gives you a little more narrative about it. So, I mean, I guess this makes sense. You're saying here's another cause of action, basically, under the Human Rights Act. If there are going to be more cases, how is the Human Rights Commission going to deal with those more cases?
Representative Arnett, did you have a question or a comment?
I do. It's a question for, I guess they're all for Peggy today. Again, how did they come up with this number? Did the Maine Human Rights Commission say we anticipate 55 cases or 90 cases, or?
I think that
what's a half a person? That
right. Well, you know, they're already strapped. So I'm sure that they were looking at this as, okay, you add anything on and we're really going to have to add more personnel. I don't know what the numbers were that they identified for the fiscal office.
Okay. So it's our job then to determine if this is important enough to place that value on an appropriation.
Right. And once again, as Representative McCreight said, if you want to question and get some more information from the commission, we can do that.
I'm sitting here on a Tuesday thinking we're not going to get a whole heck of a lot of information by a Friday, but.
Well, except that all these fiscal notes were put together with information from the agencies involved. So they have already thought about this and they have submitted information to the Office of Fiscal and Program Review. So they should be able to provide you the information and you can look at that. Or you are increasing their workload. That's the other.
Okay. I would find us in a difficult position to challenge it. I mean, I just don't know how many cases this is going to generate, but I guess somebody has to figure that out, and that's
right.
If I could chime in 2 cents. I think it's not going to be de minimis. Well, I sound like a lawyer, huh? Anyway, I think that, I think that once this is known by the people who are helping people trying to get out of these situations, that it's possible that the landlords they're trying to rent from are discriminating against them on this basis, and that that's actionable, that I think there will be a significant number of cases.
Okay.
So I'm personally in favor of sending it to appropriations with this appropriation on it.
I am as well, Representative Reckett. I think it's appropriate and that we should agree to add it to the bill.
I'm fine with that.
Okay, so this I don't think you need to revote. You just need to say, yes, this is part of our majority report.
And those in the majority, are we in agreement on that?
Yes.
That's okay, great.
Yep.
Okay, the next one was a little bit of a surprise to me, but I'm not sure that I should have been surprised. It's LD 1303, an act to ensure judicial discretion in sentencing. And if you remember, you took everything out of that bill except the piece that directed the reviser of statutes to go through all the statutes and identify every place where there was a mandatory sentence or a sentence that could not be suspended. And the reviser of statute says we don't have the staff to do that. So we would have to contract that out. And so they are looking for $11,400 to do that. So this is all that's left of that bill that was undoing mandatory sentences. So this is just identifying what they are, reporting to the Criminal Justice Committee next by January 15th, and then that committee can report out a bill once they decide how to deal with all those mandatory sentences that are currently in the statute. In order to provide that information to the Criminal Justice Committee, that is work that needs to be contracted out.
This is another one that to me seems appropriate and reasonable, and that we should accept the fiscal note.
I agree.
Yep, I agree.
Which LD, may I ask?
This is 1303. It was Representative Charlotte Warren's bill.
Great, thank you.
So you have already voted ought to pass as amended for the majority. I'm sorry, I don't know the vote count on that. So this would just, it sounds like what you're saying is this would be incorporated into the, I'm going to stop sharing the majority report.
Yes.
Okay.
Final vote was 10-4.
10-4?
Yes.
Yeah, thank you. Okay. LD 1345 is the last one that I want you to talk about, but the others I think can go much faster. So 1345 is unanimous ought to pass report. About 1345 is an act to implement the recommendations of the Right to Know Advisory Committee. This is the one with the training. We knew this was coming. Here's the mandate. So the question is how we deal with this, or how you deal with this, how I draft what you want, how you want to deal with this. So it is considered a local government mandate. It focuses on municipalities and schools. My understanding is that pretty much schools, it's just clarifying. It's not really saying more school officials have to do training than they are now, but it does say more people in municipal government have to have the freedom of access training. Freedom of access training is actually defined in the statute to, you can usually complete it within 90 minutes. And it's just a thorough review of all the information that's on the Freedom of Access Act website that Brenda Kelty maintains on the state's website. So you can see that it's an insignificant cost, but it's statewide. But because it requires municipalities to do something that they're not doing now, or some people in the municipality doing something they're not doing now, and that might have a cost to it, because if they're doing it on their work hours, then they're not doing their other things. So that's why it qualifies as a state mandate, or it could qualify as a state mandate. And certainly training in the past has been identified as mandates. And so the question is, how do you want to go forward with this? Do you want to appropriate money to pay for 90% of the additional costs, or do you want to add a mandate preamble, or do you want to say we're not going to do either one, and if it actually costs you municipal officers money, you don't have to do this? I think those are your options. Or you can push back and say this is not a municipal mandate.
Thanks, Peggy. Representative Harnett, this is your bill. What are your thoughts?
A couple of questions. First of all, I don't understand how we appropriate 90% of a number that doesn't exist. So option one seems to be impossible to satisfy. The next question would be, can we just put an emergency mandate a mandate preamble on it, and if we don't get 2/3, strip it, strip the mandate, and then just put it out to municipalities to do it or not.
Sounds reasonable.
Yeah, that seems like a good path
So I
forward.
would say put the 90% of indeterminate number seems silly. So I would say put a mandate preamble, hope we get the votes, and if not, then strip the preamble. Is that doable, Peggy?
Oh, that's definitely doable. That will require you to reconsider the bill and revote it.
Then I move to reconsider our vote on LD 1345.
And for all those in favor, oops, well, I'll second the motion. And then all those in favor, please show your physical hands so that folks watching.
4, 5, 6, 7, 8, 9, 10.
Yep. And then did you have a motion, Representative Harnett?
The motion ought to pass as amended and adding a mandate preamble.
And this one we'll do, because it's an actual vote on the motion, the overarching motion, we'll do a roll call vote on it.
Do we have a second? Did you second that, Senator Carney?
I'll second it. I think we're ready.
Okay, I'm sorry. I'm just waiting for my cue. Senator Carney.
And I was spacing out. Yes, thank you.
Senator Carney.
Yes.
Thank you. Senator Carney votes yes. Senator Sanborn.
Yes.
Senator Sanborn votes yes. Senator Keim.
Yes.
Senator Keim votes yes. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Representative Cardone. Representative Cardone is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 10 members voting in the affirmative, 0 in the negative, and 4 members are absent.
Thank you very much. And so the ought to pass as amended vote carries 10-0 with 4 absences.
Okay, those were my problematic bills. So if you want, we can just start going through the others that I sent you, if you want. Or,
great.
I mean, I don't know if you're happy to just look at them on your own rather than taking up committee time, however you want to do this.
And so, Peggy, if we were to look at them on our own, then we would just email you if we had concerns about any of them?
Or, yes, if you had questions, or we could bring them up. And if you have questions, we can bring them up at the next meeting if you want. I'm just trying to think if there are any that I know that there are several that we say, oh, we'll talk about that at language review. And I don't think any of the ones that I have sent to you so far are those bills. Like, what's the makeup of a study committee or whatever. I don't think any of those are in front of you yet. I think all those are still in processing. The only difference I might have is LD 478, which is there's a majority and a minority report, but so actually maybe we should probably look at the fiscal note on that.
Committee members, would people prefer to go through all of these or just do the minimal that we need to do in this format and then review them and report back to Peggy? Go ahead, Representative Moriarty.
Madam Chair, given the fact that the confirmation hearing this morning took a fraction of the projected time, I think it's worth our time this afternoon as a group to go through these together.
And Representative Evangelos?
Thank you, Madam Chair. Peggy just brought up 478. I had a question on it. And if we're going to do what Representative Moriarty suggested, I'll wait my turn.
Okay, thank you. Committee members, is it acceptable to committee members that we just focus and work our way through this list and get it done?
Yeah.
Okay, let's do it. All right, so Peggy, maybe we should start with 331 and just work our way down.
Yep. I have to tell you, my computer is being a little bit weird today.
If it's helpful to you, I can do screen sharing. It's totally up to you.
Okay, well, I just got a notice that my screen sharing failed. So maybe that would be good.
All right, let me give it a shot here.
I see a ghost of my PDF on my screen. It's probably good that it's not working.
All right, so I am going to try to see how this works. Actually, I think I had the wrong. Give me one moment, please.
Well, I have to tell you, I've been having trouble with my Adobe program. And since all of these are saved as PDFs, I'm just, there it is.
Okay. All right, just tell me what you'd like me to do with it and I will move the cursor around.
Great, so I don't know if you just want to scroll down a little bit so you can see the text. This is LD 331, an act to protect student privacy. This is the videos, the surveillance videos and the class videos. And the majority is ought not to pass on this bill. You had a different bill about teacher privacy. So this is a minority report that would specify that even though these recordings are not public records, that law enforcement authorities and custodial parents and guardians may access those designated video and audio recordings. So I know Representative Moriarty had dictated that information, but he hadn't, we didn't actually see it on paper.
Okay, and Representative Moriarty, is that acceptable to you?
Yes.
Okay, is that all you need from us, Peggy? It's just a yes?
Yes. Yep.
Okay.
Madam Chair, on these divided reports, would it be helpful for you to know everybody that's on the minority report?
If you've got, yes, that would be helpful. Thanks.
It's Senator Sanborn, Representative Babbage, Representative Moriarty, and Representative Hagan.
Thank you. Is that acceptable to those? Okay, great.
Okay, great. The next one is 461, and this is a divided report. This is the main care lien, and when you voted, you knew there was going to be a cost to it, and this is the cost that the Department of Health and Human Services has identified as their loss because they would have to be sharing recovery with attorney's fees. That common fund doctrine. So I think that's consistent with the numbers when this bill was before the committee last year.
Okay. Everybody all set with that one?
Yeah, I think I'm on the minority report on this one. So.
No.
The motion was ought to pass as amended,
Yes,
which
we knew
prevailed.
there would be a cost.
Right.
And so now you're looking at it.
All right, any concerns?
Yeah, Peggy, is this the cost that Representative Cardone challenged because she thought there would be greater recoveries coming into the state?
Yes.
And what happened with that?
The problem is they can't identify that. That's another unquantifiable amount, a couple of ways, because they don't know. The argument is there will be more recoveries because attorneys will take these cases.
Right.
There's just no way to quantify that.
Okay. So this is, we look at the glass half full and.
Right.
Okay.
Right. So what they've estimated is this is how much the department would have had to pay out in those cases that they've actually had recoveries.
Got you. Thank you.
So the next one is LD 478, and that is Representative Evangelos's bill on compensation for people wrongfully incarcerated. My understanding is it's a divided report, but it's ought to pass as amended and ought to pass as amended. Actually, it's ought to pass and ought to pass as amended in the, but there needs to be a way to fund it. So this is the majority ought to pass. Did you vote ought to pass as amended? Did I write that wrong? So here's the thing about funding it. We don't know how much money needs to be in it. The way this is created is it creates this fund, the Unjustly Incarcerated Persons Compensation Fund, and it puts other special revenue funds of $500 in it. So that's not an appropriation. There's also no money in it right now to compensate anybody. So if somebody wins an award, if the court identifies somebody as qualifying for an award, then the legislature will have to come and put the money in that account. So that $500 is just a placeholder.
I'm showing this is simply
The minority report.
It was just ought to pass, right?
Yes.
Yes, and I wrote that incorrectly on this paper. But what I'm saying is it should be an ought to pass as amended, so you can add in this appropriation section. It's technically an allocation, but without actually putting funds in it until they're necessary.
Representative Evangelos, go ahead.
Just a quick question for Peggy. So the $500 doesn't go to the appropriations table, then the bill's not going to die for the lack of $500, right?
I really don't know that. Let me see if I can get an answer to that. I think it might still go to the table. Because you are obligating the state to pay. Even if you're not putting the money in there, the state has an obligation to pay that.
Representative Harnett, you are next.
Thank you. And I'm a little confused. So you're saying, even though it says the majority was ought to pass as amended, that's incorrect, right?
That's incorrect. My mistake. It should have just ought to pass.
Okay. And the minority report just put a cap on the damages.
Exactly. Everything else is the same, just a cap.
The same. Okay. And the majority is still going to have to amend because it has this fiscal note.
Yes.
Got it. Thank you.
See, you're not confused.
Senator Sanborn, I think you were next.
Thanks. My question was just, usually when there's OSR, we know where the OSR is coming from, Peggy. So that's the only reason I'm a bit confused. Normally this would not go to the table because there's no general fund appropriation. But my only question is just what the OSR fund that exists is that we're doing the allocation from. But to answer Representative Evangelist, this should not end up on the table because there's no general fund cost.
So I think what the bill says is it's funded through the unappropriated surplus
of DAFs.
Wow, everything is so slow today.
I'll go back to the majority report here, Peggy.
Mm-hmm. Yeah, and I don't know that it actually, unless that's in the fiscal note.
Now let me scroll down.
Okay, is established as a non-lapsing fund. The compensation fund receives funds allocated or transferred by the legislature from the unappropriated surplus of the general fund. So, and this happens in other states where once there is a compensation award determined, then the legislature appropriates the funds for that. So this would be moving it from the general fund into this other special revenue account.
I see Representative Evangelist, your hand is up. Do you want to go ahead?
I'm listening. I've just got my hand up in case I want to chime in.
Representative Harnett, did you have anything to add?
No,
Okay.
sorry.
No, that's all right. So are we, as a committee, there's both the majority and minority report have essentially the same fiscal note. So is everybody all set with these?
I'm all set with it, but I want to get clarified the issue that Senator Sanborn brought up.
Which is whether it goes to the table?
Yeah.
I'm trying to get that information for you. They would recommend, OFPR would recommend that it go to the table.
Okay. Are these all going to the table as a big package or individually? Is there a package that judiciary is sending to the table or individual bills?
So what happens is each bill, once it has to be enacted by the House before it goes to the table, right? That's the very last step before enactment. It goes to the table. And then once you have the table full of things, each committee gets to weigh in about the things that came out of their committee that are on the table or going to the table.
Okay, so that we get a package and the committee weighs in on individual items in the package then.
Yeah, I'm not even sure I'd call it a package, but the committee gets to weigh in. I mean, if you say everything that comes out of judiciary is a package, and then the committee can give its priorities for what they think is the most important out of those bills.
So
Yes.
we get another chance to give our 2 cents then after.
You get another chance to say this is the most important thing. Yes.
Okay. And do we appear before appropriations and purpose, or are these memorandums?
This is usually a memorandum to the committee. If you're in the hall and they're in the hall.
Okay. So it's memorandum after the Judiciary Committee as a whole weighs in on all of these fiscal notes. And then we agree to send a memorandum A through Z.
That is the standard practice, yes. It means getting the committee together sometime before the end of session once most things are out. So, I mean, we'll do the best we can, but yes, you're right. And it's a memorandum that goes from the committee to appropriations.
Well, this is small potatoes, but you hate to lose a bill over $500. So.
Well, it's really not the $500. It's the obligation that the state will have to pay.
Right. If we get one of these cases. Well, we'll be taking this. I don't want to take any more time, but I just want to be clear on the process. So the committee will be taking a bunch of these fiscal note bills and talking about them and prioritizing.
Right. And you won't need to do that until they actually, get through the process. So if you have 3 bills and 1 or 2 of them die in the process, you're not going to be weighing in on those on the table.
Sure. We're just talking about things that pass the House and Senate.
Right.
And, okay. Thanks.
So I just want to make sure that was an ought to pass report. even though I wrote ought to pass as amended on it. I guess I was wishfully thinking. So you can tell me how you want to deal with that for the majority. If you want to add that, I think I've been making you vote. However you want to handle it.
I think we go to ought to pass as amended now.
Yeah.
Okay.
And are we all comfortable not doing a roll call vote, but just adding the fiscal note?
That's what we did earlier.
Okay with you, Peggy? Oh, I'm sorry, Tom, go ahead.
Isn't that what we just did earlier on the other bills?
Yes.
I think I actually made you vote on one of them though.
Okay.
But that's, you know, the main thing is that Soupy keeps track of it. It's going to be reported out, ought to pass as amended.
Correct.
Ought to pass as amended, ought to pass, as a divided report, both reports will be ought to pass as amended.
Yep.
Yes.
Okay.
Right. And you're doing this in a public theater,
Yes.
so.
Yeah, I know. And you've got the, unfortunately, in normal times, it would be easy. You've got the wrinkle of people voting by email. And so if you're really clear on what you want to do, I think they'll be okay. Because I think Representative Record thought that she had voted one way on this one. You actually, is this the one where you thought you were in the, you actually voted on the initial ought to pass?
No, it was the 461.
Oh, this is the one before. Okay, my apologies. So just so I'm clear, we have two ought to pass as amended, 9-5.
Exactly.
Okay. What I've got.
Madam Chair, may I just ask a question?
Go ahead, Jeff. Representative.
That's okay, you can call me Jeff. The ought to pass as a amended majority report is $500. That's what we're amending, right? It's the fiscal note. Okay, thanks.
Yes. Yep.
So just to be clear, that's a placeholder allocation. Right? Somebody gets an award of $500,000, then the legislature will have to fund that at more than $500.
Yeah, can't wait for the debate on that one.
Maybe you'll think of a different way to fund it by then.
The other states aren't having a problem, but let's move on.
Okay, so the next one is also a divided report, LD 483. Did you want to try to share that, Senator Carney?
I think, did I succeed?
Yeah, it looks good. Looks good.
Okay.
So all we were doing was changing debt buyer or debt collector. We were changing the definition of debt collector, and in the debt collection statute, a debt buyer can also be considered a debt collector. And so we were trying to kind of make that a broader definition, and the revisor's office said, no, you have debt collector defined in the statute right now. If you want to add a debt buyer, that's a defined term, add debt buyer too. So I don't know, did I give you the whole bill on this to show where that fits in? But this is the majority voted ought to pass as amended to make sure that debt buyers were included in paying these fees, these surcharges when filing cases. And those surcharges go to the Civil Legal Services Fund. And so we're really wordsmithing here to make sure debt collectors and debt buyers are both subject to the surcharge.
And that's fixing that sort of technical error that occurred when these collection agency actions were moved from small claims court into district court.
Right, which was done by a completely different bill.
Exactly. And I can share 483 if anybody needs to see it. Does anybody need to see it in order to approve the language change? Not seeing any hands. I'll stop the. Is everybody okay with that one?
Great.
Thanks.
The next one is 589, which is the majority report.
I'm getting there, Peggy. Hang on a second.
Okay. Oh, you're doing great. Are you kidding?
It does 589. It gets a little confusing.
Yeah, especially if you have more than one screen that is showing.
Yep, that's what's happening here. Okay.
So we're finally making progress on these bills. This is the two bills that were allowing civil actions against for sexual abuse against children to go forward no matter when the abuse occurred. And so we are writing in an application section that says this section applies to all actions based upon sexual acts toward minors, regardless of the date of the sexual act and regardless of whether the statute of limitations on such actions expired prior to the effective date of this section of the, I'm sorry, this subsection. And then we repealed that application section from 1999. So I don't think this is a surprise to you. We just hadn't put it all together because we had two bills and we pulled some things out of one of the bills and put them in the other bill. And you still have been planning to write a letter to the judicial branch, which is still needs to be done, about training and ensuring that these cases are looked at on the docket appropriately, although that's not as big a deal if there's no statute of limitations on them anymore. We don't know. There is still a chance that somebody could challenge us and say this violates their due process rights because the statute of limitations that did apply to them expired, and now the state is opening it up again. But the Attorney General's office said they were willing to help support the legitimacy of this law. So,
Representative Moriarty, did you have a question?
I did, Madam Chair. My notes show that half of the committee was absent when we voted on April 7. I wonder if we know what the final tally was.
good question.
I have it.
Thanks, Soupy.
I have 7 members voting ought to pass as amended, 5 members voting ought not to pass. I have 2 members were absent. However, I need to, 1 member voted. This is kind of, make sure I read it correctly. One member indicated they are not voting on this bill because they have not seen the amendment.
Representative Harnett?
Hi, I was knocked off the Zoom for a while. Are we voting or where are we? Or is Soupy talking about a prior vote?
We were revisiting the vote because only 7 people were in the Zoom when we voted initially.
And
this is, what bill are we on? I'm sorry.
I'm sorry.
589.
589.
Thank you.
Everybody all set with that one with 589?
Can somebody tell me what?
I can share the language.
We were just reviewing the language. Yep.
Thank you.
And I was reminding them that there might be a due process challenge. Okay, the next one is 681. I feel really bad making you do this. Oh, look at that. So this is, if you remember, Senator Libby's bill about lodging facilities and what eviction processes apply to them. And so instead of trying to amend the statute, he pulled together people to put a task force together to look at safe and stable housing in lodging facilities. And so this would have 3 legislators and 1, 2, 3, 4, 5 others on it. And I believe it's staffed through the Legislative Council, which probably means somebody from our office would do that. So, and you will see that the fiscal note is the Legislative Council has allotted $10,000 in the fiscal year to cover study costs. And so this would be the general operating, the expenses of this study are expected to be $1,750. So that would, the $10,000 would go towards that.
Does anybody need to see any portion of this before I end screen sharing? Okay.
I believe this was a unanimous report.
It was.
See, I don't think I'm necessary anymore because Senator Carney shares the screen and Representative Moriarty has all the vote totals.
You're into you and
See you
Supi are
later.
indispensable. Totally indispensable.
Yeah, take the day off.
Okay, so the next one would be 690. So this was Representative O'Neill's bill about changing the statute of limitations for assault and battery and false imprisonment to 6 years rather than the kind of anomalous 2 years that's currently in the statute. And I believe you all voted in favor of that and then said, we should make this happen as soon as possible. So you asked for an emergency preamble and clause to be put on the bill. So that's what this is. You're actually reviewing the emergency. So what's funny here is that the fiscal note is not required, but it will be included because we're amending it to put the emergency on.
Anybody want me to screen share anymore? No, okay.
No thanks. This vote was 10-0. I don't know if that changed at the finish line.
1301.
Great. So the next one is LD 737, and that is a divided report. The majority is ought to pass as amended. And if you remember, this is Representative Tepler's bill where she actually worked with quite a few different people to put together the different levels, the values of different assets that could be exempt from attachment, from any kind of suit or judgment. And there was a lot of discussion about the residence, a debtor's residence, and they scaled that back. And so this was, I won't say it's the compromise numbers, but it's the numbers that her working group came up with. It's still not a unanimous report of the committee. And there were still people who had testified at the public hearing who were not in favor of these changes. But all of this, she actually went over at the work session when you voted. So none of this, it's just a little, the format's a little bit different.
Committee members, does anybody need to continue the screen sharing? We saw it at the work session.
We remember it completely.
Got it in front of me.
Okay.
So the next one is 765. And I believe that is a unanimous report.
$12-0.
And this is it. The Department of Health and Human Services asked for this bill. I believe Representative Harnett sponsored it for them to comply with the Federal Family First Prevention Services Act, which requires additional reviews by the court, as well as looking at the placement of children in residential treatment programs.
And this is necessary to get funding, right?
Correct. And there was some give and take, and they agreed to not make it look like separate hearings had to be scheduled all the time, that the reviews would take place at the regularly scheduled reviews that the courts already do. So at every judicial review and permanency hearing that are already scheduled, that's when they have to look at the child placement situation. And you added section 5 there, which is the judicial branch asked for that they wanted to have some rules. They wanted to have rulemaking authority to go forward with dealing with all the pleading practice procedure with respect to these proceedings, since now the judges are going to have to be looking at one more thing at each one of these reviews. But I don't think that there's, I think these are cost absorbed, or it might even, I don't know if it indicates that if you don't do this, there'll be a cost. No.
All right. Everybody all set with the screen share?
Great. The next one is LD 785, and I believe that's the majority report.
This is the one where they made the language consistent with the different sections upon agreement with a lot of the different stakeholders, right?
This is the one where so 785 is the one where you had lots of different stakeholders saying, do this, don't do that. And this was the agreement that instead of looking at the standard for likelihood of serious harm for commitment, they looked at it for protective custody. What does a law enforcement officer have to recognize, or what's the standard for a law enforcement officer to take somebody into protective custody? So rather than saying somebody has to, we're going to change the standard to take away their liberty on a longer term basis, this is the standard that a law enforcement officer can actually pick somebody up and take them to be evaluated, to take them to be blue papered, to evaluated whether or not they should be involuntarily committed. So I think this was the compromise, that the people who were really concerned about restricting somebody's autonomy were saying, don't change the standard of involuntary commitment. And so this just lets the law enforcement officers identify those situations where somebody might not be able to assess the risk of their situation and can take them to be assessed. So that is the majority report. That might actually be helping some of the other things that you have bills for, like Senator Timberlake's bill coming forward. But we'll see that later.
I'm just taking a moment to open up a bunch of these, because then I won't have to toggle back and forth. And I just think things will go more smoothly. So
thank you,
if you guys don't mind.
Well, Senator Carney, if it's all right, Peggy, while she's doing that, can you, the vote on that bill, I think I'm on the majority report, is that correct?
I believe so.
Yes.
Okay, thank you.
On which one?
785, the one we were just looking at.
And so 803 is our next one. I somehow missed that one. Okay. Oops.
Thank you so much for doing this, Senator Carney.
Yeah, you're welcome. For some reason, I can't get 803 to pop up. So, oh, there it is. Okay. Hold on. All right, I think I have streamlined our process, but fingers crossed. All righty, let's do it.
So 803 is Senator Deschambault's bill about making sure that when somebody has a protection from abuse order against them from another state, and they engage in conduct that is recklessly, it puts somebody in danger of serious bodily injury, or they actually assault the person, and it's a violation of that protection from abuse order, that it's considered a violation of a protection from abuse order here. It's actually a crime. And what you're seeing here is just a cross-reference to making sure that all three of the those subsections. So subsection 1 says, except as provided in 2, 4, and 5, violation of the following is a Class D crime. So one of those orders or court-approved consent agreement. I think, Senator Carney, I stuck the whole bill in that document. If you can scroll down.
I will do that. Thank you.
So here's actually what the bill is about: is if the defendant violates a protective order or an order that is similar to a protective order pursuant to Section 4007 issued by a court of the United States. So that was really the purpose of the bill. It's a Class C crime. So if you remember that section where we were updating the cross references, that says it's a Class D crime if you violate an order, and this new subsection 5, we're saying that's a Class C crime if you're violating somebody else's protection order and you assault somebody. That's a Class C crime, in addition to it being an assault. So we were just cross-referencing. That's the only amendment, is cross-referencing that. So hopefully I'm not talking too much and mixing you up. But one thing I do have to say is Joint Rule 319 says anytime you enhance the penalty of a crime or you create a new crime, it needs to be reviewed by the Criminal Justice Committee to see what the effects are on the criminal justice system. So I have been working to put together a memo about this in the 2 bills about human trafficking, child sex exploitation, to go to the Criminal Justice Committee for their review. But so there's one more step to this.
Representative Harnett, go ahead.
Is that similar to the FOA reviews that we do? Do they have to approve it, or do they just weigh in?
They can just weigh in. The difference is theirs is created by joint rule, ours is created by statute.
Okay.
So
can they reject it?
I don't know that they can reject it. I think they can come to the floor and say there's really a problem with this bill because it has, so disruptive, but I don't think they can reject it.
Okay, thank you.
No, they just report back. Oh, look at that. 1254.
Oh, no, I'm not. I'm trying to get to 855, but again, for some reason it's not popping up, so I'm going to have to open it.
There you go. So 855 is an act regarding the issuance of a birth certificate following a gender marker change. The majority is ought to pass. The minority, there are 2 minorities. One minority is ought not to pass, and I believe there were 5 members on that report. And this is Representative Moriarty's report, I believe. And it limits the birth certificate change to those who are at least 16 years of age, that the parents can make this change only for somebody who is at least 16 years of age.
Representative Moriarty, do you approve of this?
He's off camera.
Oh.
Yeah, sorry. I do approve it for the time being. I'm not sure that I'm going to stick with it. it seemed appropriate at the time, and I've had some conversations in the weeks in between. So I guess for today's purposes, I'll go with it.
Okay, thank you.
And that's one of those seemed like a good idea at the time things.
Well, Lois, it's interesting. We passed a bill prohibiting marriage of people under 18.
Mhm.
And this bill allows a gender marker change for a child really from age 1 on up. When the child, has no capacity really to make that decision for himself or herself. And that was my concern.
Yeah, I think what I know though,
the
about
whole juvenile justice system is based upon not imposing criminal consequences on people who don't have capacity. And I just felt that if it's something of this magnitude takes place at an age where someone really lacks capacity and maturity and so forth, I had a problem with it.
Yeah, we should have a conversation sometime about another angle that we didn't deal with. So I'll talk to you when we're in the State House.
Okay, I'll be there.
Tomorrow.
Yeah. Yeah.
All right. Is our next one 868, Peggy?
Yes, it is. So this is an act to provide consistency regarding persons authorized to conduct examinations for emergency and voluntary commitment and post-admission examinations. This changes from physician or psychologist in later on in the process, not the initial evaluation for involuntary commitment, to medical practitioner. And the amendment is just fixing that cross-reference. So the bill expands who can conduct a post-admission examination and a post-admission discharge evaluation. Right now, those are limited to staff physicians or licensed clinical psychologists. This expands it to medical practitioner, which has the same definition as applies to who can make the initial determination of involuntary commitment.
Is this my bill?
And this is a divided report.
Peggy, is this my bill?
Yeah, you know what? I wrote down that this is the minority. Is that right? No, it's the majority.
And I think it is Representative Reckitt.
Yes, I believe it is.
That's the one I did at the request of the nurse practitioners.
I believe that's correct.
Yeah,
and I believe Northern Light Health testified in favor of this as well.
That's right. Okay. It's all flooding back to me now.
Right. It was a while ago. I apologize. The hearing on this bill was April 8th.
Okay.
Okay.
923, I think we have it at one time.
Okay. So 887, this was Representative Stern's bill that was originally a concept draft. I did send this to him, by the way, so he has a copy of this. And so what this bill does is it directs the Secretary of State to look at I believe it's just nonprofits, right? Nonprofit organizations, and develop recommendations for legislation or rules to increase adherence. And you'll see this wasn't actually the final version because there needed to be a comma, but I decided you could see it anyway. So I think the minority was okay with the language, but the Secretary of State, if you remember, said, we don't do this now. If you ask us to do this, we're gonna have to create like an investigations division. And so the fiscal note for this is actually an appropriation. If you want to scroll, thank you. So they're looking for one-time funding to review the current level of adherence. And they're looking at that one-time funding to be $212,000.
Just so you know, the 3 people on the ought to pass as amended are not here today.
Okay. I think that does capture what their vote was. I remember the work session on this.
Right. I
Everybody-
know that the Secretary of State said that there would be a cost to this.
Any concerns about this?
Not our bill, yep.
Okay. So the next one is 1066, an act to clarify the definition of mortgage servicer in the laws governing mortgage foreclosures. And this was a unanimous report, and there were just a few things that the practitioners were trying to tighten to make sure that it applies, it covers all the bases. And I did send this also to Gretchen Jones because she had asked to look at it as well. She works with the banks. So this is actually exactly like the amendment that you had in front of you, other than it has line numbers. So, and I don't think there's any fiscal cost to this.
Okay. Do you need me to scroll down? I'm not sure. I can scroll down just to see what's.
Yeah, so the rest of it is the bill.
Okay,
So,
great. Thank you.
No fiscal impact. Okay.
Everybody all set with this one? Looks like it. Okay.
This is so exciting. Okay, 1102, that was Senator Bailey's bill about the preliminary injunction that's automatically issued basically in divorce and separations. You asked the Family Law Advisory Commission to look at it. Family Law Advisory Commission said, oh, this is a great idea. We really need to update our law, but we're not sure this is the way to do it. We will be happy to look at it, direct us to do it, and we'll report back to you. And then we'll have some legislative recommendations. So that's what this does. It directs the Family Law Advisory Commission to do that. And then you can report out legislation to the second regular session.
Representative Harnett, go ahead.
Thank you. Just, was this the bill that allowed people like access their IRAs and things like that? With that?
Right. Right. Okay, is that, we
All
good?
set?
Okay, 1200, this is Representative Reckitt's bill, an act to bring gender parity to corporate boards. She worked with the Secretary of State's office to rework it and kind of narrow the focus and extend the deadlines a little bit. And also, these are not necessarily things that the Secretary of State's office tracks. So rather than making the Secretary of State dive into what each publicly held domestic corporation in Maine is doing, it amends the law about what has to be in the annual report for these publicly held domestic corporations, to include the number of directors they have, the number of female directors, or the number and whether or not they're publicly held, because that's actually not something that is part of their annual report. So the Secretary of State wouldn't know that just from their annual filings. So this basically requires a minimum number of female directors based on the number of directors, and it requires that information to be included in their annual report, the corporation's annual reports. So you can see H, I, and J are the things that are being added that must be reported. So the Secretary of State can then just pull up their annual reports. Most annual reports now are filed online, so they'll create these fields. So those are very easy for the Secretary of State to track.
Any questions, anybody? Representative Reckett, is this acceptable to you?
Mm-hmm.
Thanks. All set for the next one?
12:54. Yeah, I think this is the last one I have for you. Is that possible? So this is, I forget who sponsored this. Pebworth, Representative Pebworth's bill. An act shielding fire departments that install smoke and carbon monoxide detectors from liability. You just wanted to make sure that when the fire department for a municipality was taking on this task of installing, that they were authorized to do so by the municipal officers. And so that's all this amendment does. And I think I included the whole bill if you need to see the whole bill.
Would anybody like to see the whole bill?
Oh, that makes sense.
No, I remember that, I think.
Fire department's putting in smoke alarms, right?
Right.
Right.
And they're protected when they're authorized. That's what we wanted to make sure.
Right.
Yeah.
Okay. And that was a unanimous report.
Peggy, I'm sorry to make us go backwards a little bit, but I just wanted to see if, is the emergency preamble still in 483? Because I'm remembering now that we were going to take it out of there. Oh, it is. I think it's out.
Is it? I
Oh, no.
completely blank mind.
I think it is still in there, and I think that we had intended to take it out.
Okay.
And I have a note from the judicial branch that is what they had intended as well.
Okay. Is that what the majority wants, is to take the emergency off then?
Which one was that?
It's 483. It's a Civil Legal Services Fund bill about, that's the one about debt collectors and
Debt collectors.
And debt buyers, right?
And the change that happened when all that whole group of legal actions was moved from small claims to district court, but the fee didn't follow it. So now we're trying to reconnect the fee to the series of filings that it applies to. And the concern was that because it did not get unanimous support in our committee, that perhaps it would be better to take the emergency preamble off of it. Is that acceptable to committee members? Sounds like it is. Okay, great. Thank you, everyone.
Okay, and can I just say that Julie Fenn was paying attention and she will be happy to answer questions about the e-warrant system on Friday. And I will share the memo that she sent because it has a whole lot of information on it. It's a lot of information that shows why it's so expensive. So I will I'll email that, and I guess I'll post it. If I haven't already done it, I will post it in the portal for LD 679.
Thank you. Representative Harnett, I just wanted to ask you a question. Do you feel like for 483 that we should vote to reconsider and take the emergency preamble off? I feel like that would be the best step, since it's unclear to me whether we had officially decided that or not, and yet it seems as though the committee members who voted for it would be willing to do that.
I think that we should.
Okay. Do you want to make that motion?
Sure. I move to strip the amend LD 483 by removing the emergency preamble.
I think we need a reconsideration.
A motion to reconsider the committee's vote on LD 483.
And so if you can show physical hands if you're in favor of the reconsideration.
Second.
Oh, is there a second?
Second.
Seconded by Representative Reckett. All those in favor of reconsideration?
2, 3, 4, 5, 6, 7. 1, 2, 3, 4, 5, 6, 7, 8. I've got 8.
Okay.
Is that what you have, Soupy?
But I had too.
Counting myself.
Oh.
You're an honorary member.
And now I'll recognize you, Representative Harnett, for the purposes of making the motion.
I would make a motion on that we amend LD 483 to remove the emergency preamble.
Thank you. And Representative Reckett, are you seconding that one as well?
Absolutely. Yes.
All right. And this one we'll do a roll call vote on. Thank you, everyone, for attending to this after the fact.
Okay to start?
We are ready. Thank you so much.
Thank you very much. Senator Carney.
Yes.
Senator Carney votes yes. Senator Sanborn. Senator Kine. Representative Harnett.
Yes.
Representative Harnett votes yes. Representative Babbage.
Yes.
Representative Babbage votes yes. Representative McCright.
Yes.
Representative McCright votes yes. Representative Cardone. Representative Galgay-Reckett.
Yes.
Representative Galgay-Reckett votes yes. Representative Moriarty.
Yes.
Representative Moriarty votes yes. Representative Sheehan.
Yes.
Representative Sheehan votes yes. Representative Hagan. Representative Poirier. Representative Evangelos.
Yes.
Representative Evangelos votes yes. Representative Newell. I'll recall the absentees. Senator Sanborn. Senator Sanborn is absent. Senator Kime. Senator Kime is absent. Representative Hagan. Representative Hagan is absent. Representative Poirier. Representative Poirier is absent. Representative Newell. Representative Newell is absent. Madam Chair, I have 9 members voting in the affirmative, 0 in the negative, and 5 members are absent.
I think
I count wrong?
Representative Cardone is an absent rather than a yes.
She's in the room and I apologize. She's on another committee.
Oh, so okay, so she's physically in the room with you. That's got it.
I'm sorry. I'm sorry, and I didn't mark her as not being here. So I will re-vote. I will recall, I'll say what it was correctly. 8 members voting in the affirmative, 0 members voting in the negative, and 6 members are absent.
Thank you very much. And so the amendment on LD 483 passes 8-0 with 6 absences. Thank you, everyone, for the reconsideration. Sorry, I didn't pick it up when we were on that bill. And all right, Peggy, I'm going to turn it back over to you.
I'm done. You used me up. I don't have anything else for you to look at right now.
Wonderful.
But I will try to get more to you by the end of tomorrow for us to take up on Friday, right?
Yes.
And Friday I don't know if you want to do anything else today, if you want to talk about criminal records or carryovers, all those things that are looming, or we can just do them on Friday.
I think we should do them on Friday. I think that would be a better process to do them on Friday. And that way I feel like we'll be further along and be able to go through them fairly quickly.
Okay.
And could I ask you a question?
Yes.
The perpetual question I keep asking you, but when the list came out of the potential carryover bills, my favorite was not on there.
You did the Equal Rights Amendment?
Yeah, 433 was not indicated as a potential carryover.
That is my understanding, is that would be one of the bills put forward for a carryover on Friday.
Okay, so it's not something we have to vote on.
It was on the list we reviewed this morning, Ann.
Yes.
Okay, all right,
Yep.
thanks.
So
I'm just ever vigilant.
Representative Reckett, you have too good a memory because 433 was your bill in the 129th.
Oh, so it's 344 this time.
Yes, it is.
Oh, wow.
So I actually, on my list, I, for some reason, gave it a vote and did not highlight it as something that hadn't been voted yet. So
Right,
my mistake, my huge mistake. I'm sorry.
So
That's all right.
that should be yellow, Peggy. Is that right?
Yeah, I mean, I was trying to go through things that you had worked on, and I knew you were trying to vote on were yellow. The gray are criminal records bills, and the blue were things I had kind of heard rumor about that might be carried over.
Yeah, I'm just going to highlight it in yellow. Is that accurate?
You highlight that in yellow. You can do that.
Okay.
Now I need a color printer.
Any additional questions or concerns before we wrap up? I'm going to call on Soupy first. She was waving.
I don't mean to. It's only because you're going to be back in the building, and I'm going to be collecting votes for divided reports, et cetera, et cetera. So just to let you know, I'm not able to go up to your desk. I'm going to have to give it to a page. So if you get a stack of voting sheet, you won't get voting sheets right now. You're going to get jackets, and all you need to do is sign it. You've already voted. You just need to sign it. So I just want to warn you, there may be stacks of that coming toward your way.
And I'm going to warn you that they told us there would be no pages. So.
Oh, you're not having any pages? Oh, I didn't know that.
That's what they told us. So that's.
Oh.
I thought I would warn you about that.
Well, thank you. I'm going to have to punt and rethink about this now. Okay. Thank you.
Will you send us an email with the new plan, Sue?
Yeah, I will. Thank you. I didn't know that.
All right, thanks. That was a good catch.
You'd probably pay somebody in the back row to snag us on the way in.
Representative Harnett, go ahead.
Yeah, I'm looking at, Peggy, I'm looking at LD 1865 for review. Did we?
I think we did.
Did we do that? An act to amend the protection from abuse laws concerning consent agreements?
Oh, no, I don't think so.
I don't have a bill that goes up that high.
Okay.
A bill number.
With the LR or?
It's an
LD.
Maybe I pulled something out of the wrong pile.
What the heck is my?
Yeah, I think that's not. That may be last legislature.
Okay. Well, I'm still cleaning up work from the 129th. Sorry. I'll put my hand
to
down
worry
now.
about.
Yeah, I got 1719 is my highest.
Representative Moriarty, go ahead.
I do too, Chris. Yes, two questions. First for Soupy, will we have a typical schedule for Friday?
That's Peggy.
Oh, okay. Sorry.
I take my marching orders from her. So if she has a list, I'll be more than happy to put it in writing.
Well, you know what I mean, just by a routine schedule, topics, bills, whatever.
She's talking, but we can't hear her.
Peggy?
We have a few bills that we are hoping will be able to vote on Friday. And I don't know if Senator Carney or Representative Harnett want to jump in. I know there are negotiations happening as we speak, and you probably know about them. So hopefully there'll be some resolution.
Okay.
The second 1703, but the others, we're still waiting for the sponsors to check back in with us.
Okay. The second question, Madam Chair, is what time do we start on Friday?
9 o'clock.
9. Okay. Thank you.
And in fact, thank you for reminding me, Senator Carney. I will, if I haven't already done it, I don't think I have, I'll send out the sponsors amendment to LD 1703.
Oh, beautiful. Thank you.
Yep.
Great.
Representative Evangelos?
Thank you, Madam Chair. Peggy, I have an appointment at 8 o'clock on Friday, so I know I'm going to be late. any of the matters involving my bills, those study group compositions and things like that, can you make sure I'm there before you take them up?
Right, you're talking about amendment review?
Yeah, we were talking about the composition of the working groups or study groups, things like
Right.
that. I don't know what
Right,
time.
yes.
It's free, but I'll get there as soon as I can.
Yes, I think what we'll probably try to do is do the voting on bills first that are not voted, and then in anything I have drafted, I will try to get to you at least 24 hours beforehand, so you have time to look at it or and be ready for the discussion on Friday.
Sure.
So
as far as the composition of those study groups go, though, is that something you're going to draft, or is that something we do the selections on?
So Sam and I will take a first cut at things like I'm doing the one on parole. He's doing the one on qualified immunity. I'll be doing the one for Representative Pluker's bill, 1630, the proportional fines.
Okay. And then
I think that's it.
And then we do follow-ups with you in the committee.
Right, and you can say, nope, this doesn't make sense at all, or I want representation from these folks on here.
Okay.
So, but we'll give you something to start with.
Okay. Just real quick, we'll get into the rest of it on Friday, but we do have that guy, Dr. Arthur Johnson, on the parole. I want him on the parole committee. The rest of it I'll take up on Friday.
I don't think we can say his name in the resolve or the statute, but I gotcha. Experts in, yeah.
Okay, thank you. And I'll get there as soon as I can.
Okay, but that's good. I think we'll try to do work sessions first. Maybe, I don't know. We'll see what works.
Okay, thanks.
Anything else, committee members? That was a really full day. Thank you, everyone, for hanging in there.
It's good. It's good.
Yeah, we got a lot off our to-do list.
Right, definitely. And on to Soupy's to-do list.
Yes. Thank you, Soupy. Thanks, Peggy.
Thanks. Have a good night.
Bye, everyone.
Okay, good night now. Take care.
Good night.
Thank you. Night. Jeffrey. Oh, Jeff. Where are you? Are you on?
How can I get off? There we go.
Can't hear you. Let me unmute you. Hold on. Okay. Oh, you're still not on. Can you hear me? Okay. All I was going to say is that you can't study too much on Thursday night. Oh, wait a minute. Does it work?
Yeah.
There you go. There you
I'm
go.
worried that we're not even going to be home, right? I mean, we're going to be voting bills all night.
No, well, we're not working. We're not working Thursday. We're working Friday.
I'm talking about the legislature.
Oh, wow.
Right?
I don't know.
Yeah, we're doing like 90. Let me look. Yeah, we're in session.
Yeah, you are in session, but is it necessary to go midnight?
I'm not the one doing the filibustering.
I'll call in I'll call in that you have to come home immediately. Sheba needs you.
You're talking about the Bruins game, aren't you?
That's what I said. You have to plan when Peggy was saying she was going to send you all this information 24 hours in advance. And I said, you won't be able to look at it that night.
Hey, Friday, are we meeting in the Judiciary Committee room or are we zooming in?
Zooming.
Okay, thank you.
All committee meetings are, that's why the confirmation was by Zoom.
Okay.
Okay.
Maybe we'll see you tomorrow.
All righty. Have a good night.
You go, bye.